Good morning, ladies and gentlemen. Welcome to the Public Service Commission of South Carolina. We're here today in docket number 2020-263E. Let's take roll. Present in the hearing room are Commissioners Thomas, Powers, C. Williams, Belzer, and J. Williams. Joining us virtually are Commissioners Irvin and Commissioner Caston. All right, Attorney Hill, if you would please read the docket.
Thank you, Mr. Chairman and Commissioners. The South Carolina Public Service Commission will hear today in docket number 2020-263E, which is the complaint of Cherokee County Cogeneration Partners, LLC versus Duke Energy Progress, LLC and Duke Energy Carolinas, LLC. The hearing today was duly noticed for today as a virtual hearing beginning Monday, July 26 at 10 a.m. The parties and witnesses are present. Mr. Chairman, the docket is in order.
Thank you very much. Let's take appearances from the parties.
Mr. Chairman and Commissioners, my name is Jack Pringle with the firm of Adams and Reese, representing the complainant or petitioner, Cherokee County Cogeneration Partners. With me are two attorneys from Paul Hastings, Mr. William DeGrandis and Ms. Jenna McGrath. Mr. DeGrandis's pro hoc vici motion is still pending owing to an error on my part. So before we even get going, if it would please the chairman, I'd like to ask that motion to admit him for this turn be considered by the commission.
Motion granted.
Okay. Thank you, Mr. Chairman. And then we also have two witnesses, Mr. Nathan Hansen and Mr. Kurt Strunk, who will be testifying on behalf of the company.
All right. Thank you, sir. Duke Energy Progress, LLC, Duke Energy Carolinas, LLC.
Good morning, Mr. Chairman and members of the commission. This is Frank Ellerby of the Robinson Gray firm appearing for the Duke companies this morning. And with me, having been admitted pro hoc vici, are Brett Breichworth and Tracy DeMarco of the McGuire Woods firm. Please be with you.
Happy to have you with us again, Attorney Ellerby, and as well your co-counsel. Office of Regulatory Staff.
Good morning, Mr. Chairman. Jenny Pittman for ORS.
All right, Attorney Pittman, I don't know if the Office of Regulatory Staff invested in new headphones, but we can hear you loud and crystal clear. So thank you for that.
Great.
So I see that the South Carolina Department of Consumer Affairs did not intervene, but are they present? South Carolina Department of Consumer Affairs? All right, doesn't seem like they're here with us. Cherokee County Cogeneration Partners, LLC, are you ready to proceed?
We are, Mr. Chairman. I think as just to set the table a little bit procedurally, Cherokee as the complainant or the petitioner is planning to present the direct testimony of its two witnesses, Mr. Hansen and Mr. Strunk, and then Duke and the ORS will present their responsive testimony, followed by Cherokee, Mr. Hansen, and Mr. Strunk's rebuttal testimony. If that, and we've discussed that with the parties, and there's not any objection to that procedure. With that in mind, and mindful that this has been an issue in other commission proceedings, I would like the opportunity to confer with my witnesses after they give their direct testimony and before they give their rebuttal testimony, but we'll follow the chairman's preferred approach with respect to that procedure.
Okay. Any objection?
No objection from the Duke companies, Mr. Chairman.
No objection from ORS.
All right. So my understanding, Attorney Pringle, is that your witness is going to testify on direct. They're going to step down, and between the time that they step down and before they step back up to give their rebuttal, you would like to confer with them. Is that what I'm hearing?
That is correct, Mr. Chairman.
And so what you're not asking for is the opportunity to speak with them, let's say during a break. If they're still on direct, you don't plan to talk to them during that time, or if they're on the stand for a rebuttal and we take a break, you don't plan to talk with them or discuss their testimony at that time.
That is correct, Mr. Chairman. There'd be no discussion about their testimony when, as you characterize it, they are on the rack, or if there's a break and they are still on the stand for that round of testimony.
Okay. All right. Based on your requests and hearing no objections, that procedure is fine.
Okay. Thank you, Mr. Chairman. And I honestly don't, and I might just throw it to Duke about whether, or counsel for Duke about whether there was any discussion that the parties were going to do brief opening statements, or whether they had a preference for that. I might just ask Mr. Ellerby that very briefly, or Mr. Breitbart.
Yeah, good morning, Mr. Chairman. Good morning, Mr. Pringle. Based on conversations with Mr. Pringle last week, the Duke companies are prepared to present an opening statement. If Mr. Pringle, who's the complainant, or his client, should the complainant here, would prefer to proceed directly to the witness's testimony, I don't think we oppose that, but we were being responsive to his the discussion we had with Mr. Pringle last week. So I think, long story short, we can do whatever Mr. Pringle and the commission prefers.
Okay. Thank you, Mr. Breitbart. And with that, Mr. Chairman, and I appreciate the opportunity to have that colloquy. I'm prepared to let the witnesses tell the story, and would call Mr. Nathan Hansen to the stand.
All right, sir. Mr. Hansen, if you would take the stand and pause for a brief second so that you can be sworn in by our court reporter.
Good morning, sir. If you can raise your right hand to be sworn in, please. Do you swear the testimony you're about to give in this case will be the truth, the whole truth, nothing but the truth?
That's correct.
All right, Mr. Hansen, I'm not sure where your microphone is located, sir, but we barely can hear you in the hearing room. If you could get closer to your computer or closer to your microphone, that would help us out greatly.
Okay, can you hear me now?
Yes, sir. Loud and clear.
Better? Yes, sir. Okay, I'll speak up.
Well done.
Sorry.
Thank you.
Okay, Mr. Hansen, if you would, please state your full name and business address for the record.
Nathan Eric Hansen, business address is 1700 Broadway in New York, New York.
Mr. Hansen, your microphone is cutting out a little bit, sort of intermittently.
Okay, then if you can't hear me, I'll have to dial into that number, or I'll just have let me have this call my phone. I'll WebEx call my phone. Give me 1 second. Okay, could Mr. Chairman, if with your indulgence, we stand at ease while Mr. Hansen secures a better connection.
Well, if that's what he wants to do, we can hear him in the hearing room. Can you not hear him on your side?
I can hear him generally, but I think it was cutting out a little bit. Maybe, perhaps that's me.
Mr. Chairman, this is Tracy DeMarco for the Duke companies. We can hear Mr. Hansen fine from where we are.
So it may be
Okay,
you, Attorney
well,
Pringle.
It undoubtedly is. Undoubtedly the voices in my head or something like that. Just continue. Now, just if you would, Mr. Hansen, just say state your full name and business address again.
Nathan Hansen, 1700 Broadway, New York, New York.
Okay. By whom are you employed and in what capacity?
I am employed by LS Power Development, and I am the Senior Vice President responsible for energy and commercial management of our operating portfolio.
Okay. Do you hold a position with the petitioner or the complainant, Cherokee County Cogeneration Partners?
I do. I have the same title with respect to Cherokee County Cogeneration Partners.
And that's Vice President?
Senior Vice President.
Okay. Have you describe what your day-to-day responsibilities are, both with LS Power and specifically with respect to Cherokee. And I'll just refer to the complainant as Cherokee.
Okay. Day-to-day basis, I'm responsible for ensuring that all of our projects, power generation facilities, are commercialized in the various markets where they operate by selling their attributes, which is primarily energy, capacity, and ancillary services, into the markets where they're located. And with respect to Cherokee, I think, as most people know, in this proceeding, is currently under a contract with Duke Energy Carolinas, and I was involved with the negotiation and administration of the contract when it was put in place in late 2012 and in 2013. And since then, I've been involved with the attempt to negotiate an additional agreement upon the expiry of the existing agreement that's in place.
Okay. Have you caused to be pre-filed direct testimony in connection with this proceeding?
I have.
Does that direct testimony, consist of 25 pages in question and answer format?
Just taking a look at it. Yes, 25 pages is correct.
Okay.
In a question and answer format.
Right. Do you have any additions, deletions, or changes to make to your direct testimony at this time?
No, I do not.
If I ask you all the questions that appear in your pre-filed direct testimony, would your answers be the same as appear therein?
Yes, they would.
Okay. Mr. Chairman, at this time, I'd like to ask that Mr. Hansen's pre-filed direct testimony be read into the record as if given orally from the stand.
Mr. Hansen's pre-filed direct testimony will be entered into the record as if given orally from the stand.
Okay, thank you, Mr. Chairman. Mr. Hansen, did you also attach 3 exhibits to your direct testimony?
Yes, that is correct.
Can you identify those exhibits briefly?
I can. Exhibit 1 was Exhibit 1 was a notice of commitment to sell the output of Cherokee facility to Duke Energy Carolinas, dated September 17th, 2018. Exhibit 2 was Schedule PP for South Carolina for purchase power for Duke Energy Carolinas. That was approved in docket 1995-1192-E, or as an ECHO, which was effective after July 1 of 2016. And then the third exhibit was the notice of commitment to sell output of a qualifying facility to Duke Energy Progress from the Cherokee County Cogeneration Partners facility dated December 12th, 2018.
Okay, Mr. Chairman, I'd ask that the 3 exhibits attached to Mr. Hansen's direct testimony be marked for identification and entered as either a composite hearing exhibit or the best way that the commission wants to handle it as exhibits plural, if that pleases the commission.
Absolutely, sir. Nathan Hansen exhibits 1, 2, and 3 will be marked as a composite exhibit and entered into the record as hearing exhibit 1.
Thank you, Mr. Chairman. Mr. Hansen, have you prepared a summary of your direct testimony?
I haven't prepared it, but I can provide one if you would like.
Okay, please do.
Sure. Direct testimony is really, from my perspective, an outline of what the Cherokee facility is in our attempts to try to negotiate with Duke a successor power purchase agreement for the Cherokee County Cogeneration facility, which has been providing power to Duke and its customers for over 22 years. We feel that, first of all, the facility is about 90 megawatts in size, so fairly small, and it is a cogeneration facility, and it qualifies as a qualified facility under PURPA because of its meeting the efficiency and operating standards under that federal regulation. And what we tried to outline and I tried to point out in my testimony is we feel for several reasons Duke has failed to negotiate in good faith and meet its obligations under PURPA to attempt to negotiate a new power purchase agreement for the facility. A couple of examples of that is typically a PURPA or a qualified facility negotiation commences with the establishment of a legally enforceable obligation, which is really a point in time where we notify the utility that we will be committing our output to them and it would commence the negotiation process. Duke has failed to recognize either the legally enforceable obligation that we sent and established with Duke Energy Carolinas or Duke Energy Progress. And while Duke provided pricing for a new PPA, they never provided any backup for the calculations associated with their avoided cost calculations, which we have asked for on several occasions starting in early 2019, and it failed to receive until we commenced this proceeding at the commission. And then the forms of agreement that were provided to Cherokee as part of several offers that Duke provided to Cherokee were in forms that were needed to be negotiated, and they were presented with specific language in their offer letters that fill out certain exhibits and then we'll file an execution form. And that to me is not good faith negotiations where there's many provisions in power purchase agreements that need to be negotiated beyond the standard form, which appears to us to really be the form that's used for solar PPAs and are available on Duke's website at that point in time. So for numerous, really what we've tried to lay out here was we're looking for open, transparent negotiations to try to enter into a successor power purchase agreement. As we've been providing power to, we've had 2 other power purchase agreements with Duke. The last one most recently entered into in late 2012 and commenced in 2013, which I think operationally between Duke and Cherokee have operated very well, as the facilities operated with over a 60% capacity factor and continues to supply power to Duke's customers. So it's been a frustrating process for Cherokee, and unfortunately, we felt the last step to try to resolve this issue was to file the complaint at the commission to try to resolve this issue around what is the fair and appropriate avoided cost that Cherokee should be provided as part of a successor PPA. Mr. Pringle, I cannot hear what you're saying.
Please answer any questions that the parties or the commissioners may have for you.
Okay.
Mr. Chairman, this is Tracy DeMarco for the Duke Companies. May I proceed with the cross-examination?
Yes, ma'am.
All right, thank you, Mr. Chairman. And good morning, Mr. Hanson, and thank you for being here today. I'd like to start by asking you a few more questions about your background. I know you just shared some of that during your direct examination. So I heard you say that you are the Senior Vice President for Energy and Commercial Management for LS Power, and you also hold a Senior Vice President position at Cherokee. Is that correct?
Yes.
And your office is based in New York. Is that correct?
Yes.
And is that the headquarters for LS Power where your office is?
It is.
Okay. And I believe in your testimony you said you joined LS Power in 2011. Is that right? Or approximately right?
That is correct.
Okay. And did you assume the position at Cherokee at the same time in 2011?
No, I did not.
When did you first take a position at Cherokee?
It was probably around the time of us negotiating the successor PPA, the second PPA in 2012.
So you were part of the 2012 negotiations?
Yes, I was involved with them. We had, I believe, 2 other people that were negotiating directly with Duke, and I was working with those folks in terms of the agreement and establishing our positions associated with that.
Understood. And we'll talk about that specific negotiation in a little bit, but I want to keep talking about your background for just a little bit. Since you have had a position at Cherokee, which I believe is around 2012, about how often would you say you travel to the Cherokee facility? And I'll caveat that by saying, since I know we have not been a traveling society for the past year and a half, so maybe pre-COVID, how often did you travel to the Cherokee facility?
I would say I traveled there probably a couple times a year. I would say early on, we have a designated person who's in our asset management group, which when I first joined the company, I was part of that group. I am no longer part of that group, who is directly responsible for the operations and is really the point person between any, with Duke representatives related to the contract. Although I am involved with any, discussions or negotiations associated to changes with those contracts and settlement issues, et cetera.
Okay, so fair to say you're not involved in the day-to-day operations of the Cherokee facility?
Not anymore. I was involved in overseeing that originally when I joined the company, yes.
And how long has it been since you were involved in that role?
Probably 5 years,
okay.
6 years.
And aside from Cherokee, do you hold any roles, management or otherwise, in any other subsidiary or affiliate of LS Power?
I do.
And about how many of those would you say?
I don't know offhand.
Is it more than 5?
It is.
Is it more than 10?
It may be. I'm not sure.
Okay. Okay. And is your role for each of those and each of those other subsidiaries, you also hold a senior vice president role?
It may be different titles for different companies.
Would you say the practicalities of your job is similar for all of those companies?
It is.
So fair to say that you negotiate contracts for potentially more than 5, potentially more than 10 of LS Power's subsidiaries and affiliates.
I'm responsible. I mean, not all facilities have negotiated contracts in the energy space. Many of our facilities are in RTOs like PJM, which bilateral contracting, similar to the Cherokee facility, is few and far between. There are bilateral contracts for either energy or capacity products for the most part, but it's pretty limited in terms of how often we do that.
Understood. And to be clear, you don't serve in a legal role in any of those companies?
I do not.
And you're not a lawyer?
I am not.
And your testimony in this case includes a fair amount of legal analysis. And am I correct that you relied on your co-witness here, witness Strunk, for many of the positions in your testimony?
For some of the positions, I'm familiar with FERC and the PURPA requirements due to my work history, where I've been involved with several QF qualified facilities and negotiations with utilities over my career.
Understood. But just to be clear, Mr. Strunk is not a lawyer either, correct?
I don't believe it, yes, that's correct.
Okay. All right. I just want to get a few more details on the background of LS Power. Reading from your testimony on page 2, it says that LS Power owns and manages over 15,000 megawatts of generating facilities in operation throughout the United States. And LS Power has managed over 3,500 megawatts of long-term power purchase agreements. Is that still an accurate description of LS Power's ownership and operation of generating facilities throughout the U.S.?
Yeah, I think it's approximate. I'd have to kind of get the latest information.
No, understood. We don't need specifics here. But do you know in approximately how many states LS Power owns generating facilities?
Probably 10 to 12 would be my guess right now.
And do you know about how many, not specific to each state, but just overall, how many generating facilities LS Power owns?
It's 20, mid-20s.
Okay. And are those primarily solar facilities, or is there a mix of resources?
Well, I would say mid-20s, but then we just recently purchased a solar portfolio from PSC that had 26, so maybe it's around 50 at this point.
Thank you for that clarification. And then I'll repeat my follow-up question, which is are those primarily solar, or are they other types of generating facilities?
Now, the majority of our portfolio consists of gas-fired combined cycle or peaking facilities. We also have a significant amount of pump storage hydro. We have a fairly large battery portfolio. We have wind facilities, and as I mentioned, we have solar facilities also.
And do you have other cogeneration facilities aside from the Cherokee facility?
We did in the portfolio. We don't right now, I don't believe.
Okay. And okay. Looking a little bit at the background of the Cherokee facility. So you say in your testimony that you lead a team that manages Cherokee's commercial arrangements and relationships with Duke Energy Progress and Duke Energy Carolinas. And in your testimony, you define them together as Duke, which we're all guilty of defining them together as Duke. It's a mouthful to say both of the company's names, but just to be clear, you're aware that DEC and DEP are separate entities, correct?
I understand that they are, yes.
Mm-hmm. And that they provide electricity service to customers independently from each other?
They can, although I think if there is the joint dispatch agreement where it's supposed to be utilized to efficiently utilize resources of both companies to for the benefit of their customers.
Well, I think we have some witnesses coming up who will speak to that, but just for our purposes, you understand that DEC and DEP file separate IRPs, they operate separate generation, transmission, and distribution systems, and importantly, they're regulated independently from each other.
Yes, and I also do understand that, and I understand that DEC under the joint dispatch agreement is supposed to dispatch DEP and DEC's assets for the benefit of its customers.
And again, I think we'll get into that with some of Duke's witnesses. So when you say on page 1 of your testimony that you manage Cherokee's commercial arrangements and relationships with DEP and DEC, it's fair to say that Cherokee to date has never had a formal contractual relationship with DEP.
That's correct.
Okay.
It's only been with DEC.
Right. And so before approximately December of 2018, or Cherokee never engaged in any commercial negotiations with DEP, isn't that right?
Yeah, other than the representatives or call it DEC or DEP are the same individuals that we'd be talking to. So
sure, but when they were speaking to you before the fall of 2018, fair to say they were speaking in their capacity as DEC representatives?
Yeah, I assume so.
Okay. All right. So now I want to walk briefly through the history of the contractual relationship between DEC and Cherokee before we get to talking about the negotiations that started in 2018. So to be clear, you weren't involved in negotiating the original PPA between Duke and Cherokee, correct?
I was not.
But you are familiar with it?
It's been a long time, but somewhat familiar with it.
Sure. I'll represent to you that I believe it was executed in 1994 and then amended in 1998. Does that sound about right to you?
Sounds about right.
Okay. And are you aware that I'm going to refer to it as the 1994 PPA so we can keep them all straight, but are you aware that the 1994 PPA was structured as a must-take agreement, meaning that DEC was obligated to purchase any and all energy that Cherokee dispatched from its facility? And I believe that you refer to this type of relationship in your testimony as a as-delivered structure.
Yes, that was the original form of the contract. That's correct.
Okay. And so Cherokee did in fact operate under that type of must-take arrangement for the term of that first PPA. Is that right?
Well, there were some revisions made to that agreement, I think, in the early 2000s, where there was a mutually, negotiated arrangement where that modified that must-take obligation. So the parties could determine whether it made sense for them to shut the facility down, and then they determined how to compensate Cherokee separately versus having to run the facility and put power to Duke, maybe at times when Duke didn't need the power. Understood,
but fair to say for at least part of that, of the term of that first 1994 PPA, it was a traditional must-take agreement.
Yeah, right. I guess the, the first half of that.
Okay. All right, and so after the 1994 PPA, there was a second PPA negotiated between DEC and Cherokee in 2012, and that was, you said that was, you participated in negotiations for that PPA, correct?
Yes,
Yep. And that was for a shorter, approximately 7-year term, is that right?
that is correct.
And then unlike the 1994 PPA, the 2012 PPA was structured as a tolling agreement, correct?
It was.
So fair to say, I don't know, you mentioned in your opening that the relationship between DEC and Cherokee has gone on for about 22 years now. But fair to say for at least part of that relationship, Cherokee facility was operating under a must-take agreement structure.
Yeah, if I did the math, maybe first portion of the first PPA it did, yes.
All right, thanks for that. Okay. Let's talk about now the negotiations that started in September, or the back and forth between the parties that started in or midway point of 2018. So I'd like to share my screen and show you, see if I can do this without. All right, Mr. Hanson, can you see the document on my screen?
I can see it. If you could make it a little bit bigger, it would be a little better.
Yep, how's that?
That's fine.
Okay, great.
Thank you.
So this was attached to your direct testimony as Exhibit 1 and was just admitted into the record as part of the composite Exhibit 1. And it appears to be a letter from, I'm going to scroll down to the bottom here. It says Carolyn Murph. Am I pronouncing that correctly?
You are.
Okay. So letter from Carolyn Murph of Cherokee to Mr. Michael Keene and others at Duke Energy Carolinas. Have you seen this letter before? I assume it was in your testimony, so you're familiar with it. And who is Carolyn Murph?
She is a peer of mine that she manages our asset management group, which the asset managers oversee the operations and kind of day-to-day interactions of the facilities.
Okay. And would she have consulted with you before writing this letter, or did you see it before it was sent?
Yes, I did.
Okay. And so would you agree that this letter marks the first attempt by Cherokee to get a new PPA with Duke to start in 2021, following the 2012 PPA?
I think this, there was actually a tour of the facility, I believe sometime in the summertime before we sent this letter, where we indicated our interest to commence negotiations with, and Mr. Keene visited the site. I was not there. It was two folks from our facility, or our organization were there. But this would be the first point in time where, you know, we establish our legally enforceable obligation that kind of puts a stake in the ground that we are ready to commence negotiations and try to negotiate a successor PPA for Cherokee.
Understood. So looking at the wording of this letter, if you would, for me, would you read the third sentence in the first paragraph? It starts with "by submitting." Kind of put my cursor there.
By submitting this notice, Cherokee is making a legally binding offer of all capacity and energy associated with the facility to DEC as of January 1, 2021, the day after the expiration of its current power sales agreement between Cherokee and DEC dated June 28, 2012.
Thank you. So you would agree that with this letter, Cherokee was offering to sell 100% of its energy and capacity. Is that right?
That's right.
And are you aware that a week later, Cherokee submitted a bid as part of DEP's 2018 non-PURPA competitive solicitation for new capacity?
I am.
And did you participate in preparing that bid proposal?
I did.
And do you recall whether the offer that Cherokee made to DEP was for all of it or part of its energy and capacity?
I believe it was all of it.
So a week after sending this letter to DEC offering to commit all of Cherokee's energy and capacity, Cherokee then submitted a bid to DEP offering to also commit all of its energy and capacity. Is that right?
Pursuant to the RFP, which I don't believe was binding, the RFP submittal, but we also hadn't received any response to our negotiation with DEC in terms of what Duke's avoided cost rates would be. So
Understood.
that's correct.
But ultimately, with respect to the RFP, Cherokee's bid was not successful. Is that right?
That's correct. That's what we were told.
And do you recall or do you know why?
I believe they said our bid was too high.
I'm going to flip to the next document I have here, which was shared with the parties and pre-marked as Hansen Cross Exhibit 1. This is this large enough for you to see, Mr. Hansen?
Yes.
Okay, so this is an October 5th letter from Mr. Keene to Ms. Murph. And Mr. Chairman, this letter was attached as part of Exhibit 2 to Mr. Keene's pre-filed direct testimony, and the parties have stipulated to the authenticity of this document. So I would ask that it be marked as the next hearing exhibit.
All right. How would you want the document identified?
This could be Hansen Cross Exhibit 1.
Okay. Hansen Cross Exhibit 1 will be marked and entered into the record as hearing Exhibit 2.
Okay. Thank you. Okay, so Mr. Hansen, you just testified that in the week between Ms. Murph's first letter to Mr. Keene and others at DEC, they had not received a response to that offer to sell energy and capacity before making the bid to DEP. Would you agree that this October 5th letter responds to Cherokee's offer to DEC?
It's a response to it. Yes.
Mm-hmm. And if you recall, did Ms. Murph share this letter with you after receiving it?
Yes.
Okay, so you recall seeing it in October 2018.
That's correct.
Okay. If you would, please read the first two sentences of the second paragraph.
Notwithstanding the foregoing, subject to the conditions set out in this paragraph, DEC is prepared to commence negotiations with Cherokee for a new PPA that would become effective on or after January 1, 2021. DEC also agrees to provide Cherokee indicative avoided cost pricing based on DEC's forecasted avoided costs calculated as of September 2018 as requested.
So to be clear, in this letter, DEC is committing to provide Cherokee with its avoided costs calculated as of September 2018. Is that right?
That's what they are saying they're going to do, yes.
Okay. And would you agree that September 2018 is the date by which Cherokee wanted the avoided costs to be calculated?
It is. I believe that's because of our legally enforceable obligation. That's what we established our right to. Yes.
Understood. And we will have witnesses that I think talk about that later. But down in the same paragraph, do you see that I understand that there were no avoided costs provided with this letter, but do you see that DEC is promising to provide them by October 31st, 2018?
I do see that, yes.
Okay. And on page 2, would you please read the first full sentence?
Sorry, which one?
Sorry,
Starting
page
with
2,
the avoided
yes.
costs?
Yep, starting the avoided costs.
Yes, the sentence reads, the avoided cost pricing will remain available for 60 days from the date delivered by DEC to allow a reasonable amount of time for the parties to conclude any needed negotiations regarding the form of the deed.
Thank you. And do you recall whether DEC in fact sent its avoided costs to Cherokee by October 31st, 2018?
They sent some PPA pricing. We couldn't determine if they were their true avoided costs or not.
But they did, as promised, provide avoided costs to Cherokee by October 31st.
They provided pricing for on-peak and off-peak energy only.
Okay, I'm gonna flip over to the next document I have here. Make it a little bit bigger for you. This is an October 31st letter from Mr. Keene to Ms. Murph. And this was also attached to Mr. Keene's testimony as part of his Exhibit 2, and the parties have stipulated to the authenticity of it. So, Mr. Chairman, I would ask that this be marked as the next hearing exhibit.
All right. And how would you like this document identified?
This can be Hanson Cross Exhibit 2.
All right. Hanson Cross Examination Exhibit 2 will be marked and entered into the record as hearing Exhibit 3.
Thanks very much, Mr. Chairman. So, Mr. Hanson, would you agree that this is the letter that Mr. Keene promised to send on October 31st? Is that correct?
It is, yes.
And did you see this at the time it was sent to Ms. Murph?
I did.
And so, and here I'm looking at the middle of the page, you would agree, I understand that we don't agree on the, perhaps on the calculation of the prices, but you would agree that Duke here is providing avoided energy prices to Cherokee.
They are providing, I assume they're avoided energy pricing. We're not sure of how they were derived, nor did they include any capacity.
And you see that the first sentence here of the second paragraph says the rates included below have been calculated using DEC's standard system methodology for qualifying facilities based on DEC's September 2018 system costs.
I do see that that's what it says. However, we have not been provided the information until we started this proceeding to be able to try to validate that.
And to be clear, after receiving this letter on October 31st, 2018, Cherokee did not immediately submit a request for information to support these rates. Is that right?
We had a phone call to talk about the rates and why they didn't include capacity. And then, we subsequently, at the direction of Mr. Keene, identifying that DEP has a capacity need, filed a legally enforceable obligation with DEP. So that's the direction we went when we received that pricing. And I believe it was in April of 2019. Then we requested the backup information for both these rates and the rates that we received from DEP.
Understood. But contemporaneously with receiving this letter, you did not request supporting information until about 9 months later in April 2019, correct?
No, because we were guided to, if we wanted capacity payment, to try to contract with DEP, who had a nearer term capacity.
Understood. And so
that's what we did.
So one of the things that you highlighted in your opening direct testimony was that Cherokee does not believe that the companies have approached these negotiations in good faith. And is it fair to say that one of the grounds for that is that Cherokee alleges that that the Duke companies were not transparent or timely in terms of responding to Cherokee's requests?
I think they were not timely in responding to the support necessary for us to evaluate whether or not the pricing provided was truly their avoided costs. And then for a period over time, they continued to, put a deadline on the available time period that these rates are available for, 60 days, which I don't think under PERPA is allowed for. So there were numerous things that I outlined in my summary, including the form of agreement, which seems like we're starting from scratch with the solar PPA versus trying to negotiate an arrangement that would be prudent for both parties, since we've been under a PPA for over 22 years. This seemed a more practical starting point. But
I understand that you have many allegations that you believe support your contention that we didn't act in good faith. But would you agree that looking at this brief time period that we've just been looking at, that this document shows Duke responding in a timely manner as committed to provide avoided cost rates, and I believe there was also a draft PPA attached to this agreement as well?
no, because I think if you read the last paragraph, it's like there's a sentence that says, if you desire to proceed with this transaction, please include our contact information, complete exhibits 1 through 1, 4, and 5, and then they'll prepare an execution copy. That's not a negotiation. It's not responsive to trying to enter into an agreement. So my opinion is, here's a solar PPA effectively. Here's your energy rates, no capacity. Basically, sign up, take it or leave it is not a good faith negotiation, in my opinion.
Well, Mr. Hanson, we'll get to Cherokee's responses to this particular letter, but fair to say that Cherokee never circulated a marked up power purchase agreement to Duke that had different provisions that would serve as a counterpoint to negotiations.
We did not, based on the conversation that we had with Mr. Keene following the receipt of this letter. That's correct.
Okay, I'm not going to show you a different document right now. So, and I understand that following the receipt of this letter, about a month or so later, Cherokee did circulate what I would call a counteroffer, which was a term sheet to Mr. Keene, and that was on December 7th, 2018. Is that right? Subject to check on the date.
I believe that sounds about right, yes.
Okay, and do you recall whether DEC or Mr. Keene timely responded to that counteroffer term sheet?
I believe they just rejected it, but I'd have to find out
Okay,
what the exact response was.
Showing you what was okay. I'm showing you what was previously marked as Hansen Cross Exhibit 3, and this is an email from Mr. Keene to Aaron Pupa, who I believe is a Ellis Power employee, sent on December 21st, 2018. This was attached to Mr. Keene's pre-filed direct testimony as part of his Exhibit 2, and the parties have stipulated to its authenticity. So, Mr. Chairman, I would ask that this be marked as the next hearing exhibit.
Hansen Cross Exhibit 3 will be marked and entered into the record as Hearing Exhibit 4.
Thank you, Mr. Chairman. So before I get into the substance of the document, Mr. Hansen, who is Aaron Pupa? And am I saying his name correctly?
You're saying it correctly. He's no longer with the company, but he worked in what we would call our origination department. So he would have contact with customers to negotiate offtake agreements with or short-term energy sales, et cetera.
And was he part of the discussions with DEC in the fall of 2018 to execute a new PPA?
He was involved with our internal discussions, and yes.
And did he send the term sheet to Mr. Keene on December 7th, 2018, if you recall?
I believe he did, yes.
Okay. So if you would, please read for me the first two sentences in this body paragraph for the email.
The one back from Mr. Keene. So thanks
Yes,
for
the
sending me this term sheet.
Yes, please.
Okay.
Sorry, I guess actually, if I could, the first three sentences, I was discounting the first short one.
Thanks for sending me this term sheet. As I mentioned on the phone, DEC is not actively pursuing any capacity at this time because DEC does not currently have capacity need. In addition, the pricing included in this term sheet is well above DEC's avoided cost we sent you on 10/31/18. It is also higher than the current market price for capacity delivered into DEC.
So you would agree that with this email, Mr. Keene was informing Cherokee by way of Mr. Pupa that the avoided costs that Cherokee calculated were well above, in DEC's view, their actual avoided costs, and also that DEC did not have a capacity need. Is that correct?
That's what he was informing us of in this letter or email.
And if you know, isn't it true that neither Mr. Pupa or anyone else from LS Power ever responded to Mr. Keene's email? In written form anyways?
I don't know if there was a written response or not. I don't know.
And so, you didn't otherwise respond to his concern that Cherokee's offer was well above DEC's avoided costs?
As I said earlier, we had no way to verify whether it was or was not. And it seemed inconsistent with the published large QF rates in effect at the time for DEC. So that didn't make any sense to us. But as I said, because it was communicated to us that DEP had a nearer term capacity need, we were then going to try to commence negotiation to provide Cherokee's output to DEP in an attempt to try to reach an agreement that would be beneficial for both parties.
So fair to say, Cherokee did not sign the PPA or otherwise accept the avoided costs before the 60-day period for accepting and committing to sell had expired?
We did not, because it was unworkable in how it was presented to us.
Understood. Okay, so I would like to talk a little bit about the DEP offer that you just mentioned. And I'm going to show you, I believe this is Exhibit 3 to your pre-filed testimony and was entered into the record as Composite Exhibit 1. This is an email from, I believe, Ms. Murph to Mr. Keene, dated December 12th. And would you agree that this is the letter that offers to sell capacity and energy to DEP under PURPA?
That is correct.
And in the first paragraph, I'll ask you to read the sentence that begins with "by submitting."
By submitting this notice, Cherokee is making a legally binding offer to offer all capacity and energy associated with the facility to DEP as of January 1, 2021, the day after expiration of its power sales agreement between Cherokee and DEC dated June 28, 2012, effective between July 1, 2013 and December 31, 2020. power sales agreement.
Thank you. And so here again, you would agree that Cherokee is making an offer of to sell all of its capacity and energy to DEP. Is that right?
That's correct.
And this letter was just sent just a few days after Cherokee circulated its counteroffer to DEC, correct?
That's correct.
You'll bear with me one moment. Okay, I'm gonna scroll to the next page and see in this first full paragraph, Ms. Murph states that Cherokee notes that DEP does not have a capacity need as evidenced by its 2018 Integrated Resource Plan and its recent request for proposal for capacity issued by DEP dated August 27, 2018. Therefore, even if DEP does not have a capacity need, companies can make the most efficient use of existing facilities and can avoid unnecessary capacity additions or procurements by facilitating Cherokee's PURPA of energy and capacity to DEP. So I believe this is consistent with the testimony you just gave, which said that fair to say the reason Cherokee offered to DEP instead of following through with its offer to DEC is because of the more recent capacity need.
Yeah, I think there were a couple words mispronounced in your reading, but that is the case. Yes.
Okay, and then the letter here says that the Duke companies can avoid unnecessary capacity additions by facilitating Cherokee's PURPA of energy and capacity to DEP. You would agree, though, that DEP's September 2018 non-PURPA capacity solicitation preceded this letter, correct?
Yeah, I don't know when those, that procurement, when they awarded those.
Understood, but at least.
But the RFP was in process, I guess, when we sent this.
Well, to be fair, you already testified that Cherokee had already been informed that it did not have a winning bid in that RFP proceeding, correct?
Right, but that was not part of Cherokee's PURPA.
Understood. My question here is fair to say that DEP could not avoid any capacity that it procured as part of that RFP that occurred earlier in the fall of 2018.
I'm not sure that's true because I don't know when they awarded those contracts pursuant to that RFP.
Understood, but assume for the moment that the contracts were awarded in the fall of 2018, you would agree that DEP could not avoid that?
Because I'm not sure that they were. I believe they may have been awarded after that. If they were awarded before December 12th of 2018, whatever the date of this letter is, I would agree with you. And they were approved by the commission if they needed to.
And do you recall whether Mr. Keene, on behalf of DEP, responded to this offer from DEP?
I believe he did, yes.
Okay. Do you recall when he responded to this letter? I'll help you out there. Subject to check, would you agree that DEP offered its avoided costs to Cherokee that were calculated as of December 2018?
Could you repeat the question?
Sorry, yes. I'm not trying to get you to commit to a date when it happened, but subject to check, would you agree that DEP offered its avoided costs to Cherokee and that those costs were calculated as of December 2018?
I believe that is the case. That's correct.
And do you recall whether Cherokee submitted any alternative avoided costs to DEP like it did for DEC?
I don't believe we did. I believe we followed up after receiving DEP's rates, which are now looking at it, looks like it's in February 2019. I believe we followed up, formally, written wise, requesting specific information such that we could attempt to calculate what we thought both DEC's and DEP's avoided costs were.
Understood, and we will get to those requests for information, but I want to get through each of the offers that were made first before we go into the exchange of information. So fair to say that Cherokee did not accept these avoided cost rates, the December 2018 DEP avoided cost rates.
That is correct. We did not.
And the rates that were offered for 60 days expired without Cherokee taking any action.
I guess I'm not sure what expiration means in this context. It just seems to be a process that Duke has invoked, but that's fine. It did.
But you agree that that was the term for which the rates were offered in the letters Mr. Keene said, correct?
That is what the letter said, yes.
Okay.
That is not what I believe the obligations under PURPA requires.
Understood that we have differing opinions on that. Okay, I want to just go through briefly the other offers that were made, because I believe there were, correct to say, there were 5 total avoided costs that Duke offered to Cherokee.
Okay.
I'm sorry, I didn't catch that. Are you agreeing?
No, I think you made a statement that you wanted to walk through other offers.
Oh, sorry about that. Okay, so yes, so fair to say there were 5 total avoided cost rates offered to Cherokee from either DEC or DEP. We have and in addition to the 2 we just talked about, would you agree that that DEP circulated avoided cost rates to Cherokee in June 2020? And Mr. Hanson, if you need, I'm happy to.
Yeah, I'm just trying to confirm when they were provided.
And if it's easier, let me. Okay, I'm going to show you on the screen here. This is a timeline, petitioner's timeline of events that was filed in December of last year as part of this proceeding. And Mr. Chair, and scrolling down to the end, I believe it, under the certification, has your signature. Does that look right to you?
That looks right to me, yes.
Yeah, and Mr. Chairman, if I may, I'd like to mark this as the next hearing exhibit. We'll call this the petitioner's timeline of events.
The petitioner's timeline of events will be marked and entered into the record as hearing exhibit 5.
Thank you, Mr. Chairman. So Mr. Hanson, to help us out with these dates, I'm going to scroll down to this entry, June 24th, 2020. Does that reflect your recollection that DEP circulated avoided cost rates to Cherokee in June 2020?
They did, apparently, yes.
Sorry, was that an agreement?
They provided us a letter with 5-year PPA that included their avoided costs. I don't think those avoided costs were consistent with their obligation under PURPA because they weren't calculated as of the date we established our legally enforceable obligation.
Understand the difference of opinion there. fair to say that this June 24th, 2020 offer of avoided cost rates, this was in response to a request for Cherokee, from Cherokee, for avoided cost rates, and that's the previous May 4th, 2020 entry, is that right?
That's correct.
Okay. And then the next time Duke offered avoided costs to Cherokee, I believe, was in September of 2020. I don't believe you have that here on your timeline, but would you agree that DEC circulated avoided costs to Cherokee in September of 2020?
It could be, if you could pull up what the offer was, I could confirm that.
Sorry, I don't have the terms on hand for an exhibit, but
Well, I just can't recall if that's.
can we just agree to fall of 2020?
Counsel,
Yes.
counsel, Mr. Witness.
So I'm sorry, Mr. Chairman, I did not catch that.
Mr. Hanson.
Yes.
Counsel,
Yes, Chairman.
Mr. Hanson, if you two could do me a favor, witness, or Mr. Hanson, excuse me, when counsel asks you a question, if you would just take a pause and then answer the question. And counsel, if Mr. Hanson or any other witness is attempting to answer your question, even if they're not giving you the answer you want, and you need to ask a follow-up question, if you would just pause and allow them to finish their thought or his thought in this matter, it will help us keep track of the testimony a little bit better, the questions and the testimony. Is that fair?
Absolutely. Thank you, Mr. Chairman. We will make sure to give each other time to respond.
All right. Thank you, ma'am. Thank you, sir. Please proceed.
Thank you.
So I'll rephrase that last question. Do you recall an offer from DEC to Cherokee of avoided cost rates? Sorry, not an offer, just a circulation of avoided cost rates from DEC to Cherokee in the fall of 2020?
I don't recall a written communication of an offer, if that's what you're referring to.
Do you recall that that DEC did give to Cherokee, whether orally or written, in the fall of 2020 avoided cost rates?
I believe Mr. Keene, over a phone call, provided certain rates that we could extend the existing tolling agreement on. I believe it was around that time frame, which then we responded to.
Okay, and the third time, I guess the fifth and final time that either DEC or DEP circulated avoided cost rates to Cherokee was in February of 2021. Would you agree with that?
Yes.
Okay. And fair to say, of those, we've gone through 5 times that avoided cost rates were provided to Cherokee. Fair to say Cherokee did not accept any of those rates. Is that right?
We did not, and that's, as I've explained before, we had a difference of opinion of what should be included in those rates and whether they were truly Duke's avoided cost rates.
Understood, and I am going to get to that in just a moment here, but I just want to clarify in the fall 2020 offer and the February 2021 offer. So that would be the two most recent offers from Duke. They were structured as a dispatchable tolling agreement with 10-year terms, as Cherokee requested. Is that right?
I believe that is correct. Yes.
And Cherokee still rejected those rates and the associated PPAs.
Well, I don't think there was a form of PPA. I would presume it would be an extension of the existing PPA, and there was a term sheet provided in the last offer that had some other language that would still be left to be negotiated, but we did not accept either of those consistent with my prior responses that we were still trying to evaluate what the true avoided cost was that Cherokee has a right to receive, which was based on the date that we established our LEO back in 2018.
Understood, but I just want to make clear that earlier you said that Cherokee took issue with the form of PPA that was circulated to it by DEC and DEP, and I just want to make sure that you agree that the last two exchanges with DEC, there was an understanding that the agreement would be a dispatchable tolling agreement and subject to a 10-year term, correct?
Well, I think the fourth offer, the one made verbally, was made in light of, it would be in a similar form to the tolling agreement, but it was not approved rates. I believe it was Mr. Keene trying to see if we could negotiate a deal and get something done, but it was not approved in any form that I'm aware of at the EC. Didn't issue written avoided cost rates. The final offer, yes, it was supposed to be in the form of a tolling agreement. My reference to the form of agreement was for the first two offers. It looked like the form of the solar PPA, modified very, very little to reference Cherokee, but that was my reference to. There would be a lot left to negotiate. It was an unworkable form for a facility like Cherokee.
Understood. And I want to take two things that you just said. So you said you didn't know if the September 2020 rates were approved. Are you talking about an internal Duke approval?
Yes.
So to be clear, Mr. Keene did, if it wasn't on a formal piece of paper, it sounds like what you're saying the offer was, correct?
No, Mr. Keene communicated to me on the phone that here's some rates I can try to get through. Let me know if these will work for you, and I can try to do something next week.
And
that's why I don't think it was approved internally.
And at that time, did Mr. Keene also represent that DEC would be amenable to a dispatchable tolling agreement and a longer term?
He did, and it's kind of where we started the negotiations in 2018, but at least our conversation, but that's not the direction it went.
Understood. And you also mentioned that the form of PPA that was offered to Cherokee in the fall of 2018 by DEC and DEP was targeted to look like a solar PPA. Wouldn't you agree, though, that the must-take structure of those PPAs, and I think we've already agreed to this, was the same as the original 1994 PPA structure between Cherokee and DEC?
I think the overall nature that here are certain rates that you'll be paid for delivering energy during certain periods of time were the same, but I haven't compared the agreements, the first PPA versus the agreements that were provided, but the nature is similar, yes.
Understood. Thank you. Okay, we've kind of danced around this topic for a minute here, but let's now talk about the requests for supporting information that Cherokee made to DEC.
Counsel,
yeah.
I'm sorry to interrupt, but if you're finished with the document, would you mind not sharing your screen or no longer sharing your screen while you conduct your cross-examination?
I would be happy to do that, Mr. Chairman. I will tell you that I do have several more documents I'm going to get through, and we may have just briefly intermittent periods where we don't have a document on the screen. But for now, I will stop sharing my screen.
Thank you, ma'am.
Mm-hmm. Okay, if you will bear with me for just 1 minute, Mr. Hanson. Okay, so let's, and I apologize, Mr. Chairman, because I am about to show another document, but I'd like to start talking about Cherokee's first offer to sell the DEC, and we've already established that happened in that DEC circulated rates in October of 2018, and I'd like to show you what I've pre-marked as Hansen Cross Exhibit 5, and if you will bear with me, I'll find that. Okay, this is Cherokee's responses to Duke Energy's third request for production of documents and interrogatories. And Mr. Chairman, I would ask that this be marked as the next hearing exhibit.
All right, that looks like Cherokee's complaint.
Oh, no, and I believe what I see on my screen is
Oh,
Cherokee
responses.
responses, yes.
All right.
I'll make sure we're all looking at the same document.
Energy. We are.
Okay. So if that could be marked as the next hearing exhibit, I would appreciate it.
All right. So this document will be marked as Hansen Cross Exhibit 5 and entered into the record as Hearing Exhibit 6.
Thank you, Mr. Chairman. Okay, Mr. Hansen, have you seen this document before?
Yes.
And did you assist in preparing the answers?
Yes.
Okay. I'm gonna scroll to page 5. And if I zoom, can you still read it if I zoom to this magnification?
Yes.
Okay. All right, I'm gonna look at Cherokee's response to request 3-10, and looking at this question and answer, is it fair to say that the first time Cherokee asked for information supporting the October 31st, 2018 rates provided by DEC was April 30th, 2019?
That is correct.
Okay. And do you recall when Cherokee first asked for information to support the avoided cost rates DEP provided on February 1st, 2019?
I believe it was on the same date.
Okay, and that's reflected in the response here to number 3-11, correct?
Yes.
And so for both DEC and DEP, more than 60 days passed from the date that Cherokee received the rates until the date it asked for supporting information. Is that right?
That is correct. As I explained before, we shifted to establish a LEO with DEP because their nearer term capacity need. I believe we got those responses in February from DEP's rates, and then it was in April when we requested the supporting information. That's correct.
Understood, but even for DEP, more than 60 days had passed since you received the rates and when you asked for supporting information, correct?
That's correct.
Okay.
But I don't believe that was on a written basis. I don't believe there was no other communication between the parties during that period.
Understood. And so for both DEC and for DEC, it was nearly 6 months between receiving the rates and asking for supporting information, correct?
It was.
And for DEP, which I believe you received those rates on February 1st, 2019, and this document, I will scroll to the end and show you that it is dated July, sorry. It's not right. Well, it appears to be, I'm on the wrong document, apologize for that. It was in the end of it. Let me start again and rephrase that question. So you received rates from DEP on February 1st, 2019, and then asked for these rates. I believe it was on April 24th of, April 30th of 2019. Is that right?
We asked for the background information such that we could try to calculate for ourselves and validate the rates that DEC and DEP have provided to us, that they represent the reported cost rates. Yes.
Understand that. But for DEP, it was still nearly 3 months between receiving the rates and asking for the supporting information, correct?
Yes, on a written basis, that's correct.
Okay, so I'm going to now show you what was pre-marked as cross exhibit 6, and bear with me while I find it. Yes, so this is a June 14th letter from another letter from Mr. Keene to Ms. Murph, and it was part of Mr. Keene's pre-filed direct exhibit 2 and stipulated to the parties. So, Mr. Chairman, I'd ask that Hansen Cross exhibit 6 be marked as the next hearing exhibit.
Hansen Cross Exhibit 6 will be marked and entered into the record as Hearing Exhibit 7.
Thank you, Mr. Chairman. Mr. Hansen, have you seen this document before?
I believe so, yes.
And would you agree that it is written by Mr. Keene on behalf of DEC as a response to Cherokee's April 30th request for information supporting DEC's and DEP's rates?
It is.
Now, I want to show you, I'm looking at page 20 of your testimony, and you say there that while Duke's letter contained a brief explanation making reference to Cherokee's detailed requests, Duke provided none of the information sought by Cherokee. At this time in June of 2019, did Cherokee respond to this letter from Mr. Keene?
I don't recall if we did or not.
Okay, well, let me try to refresh your recollection there. I'm going to go back to your timeline, which was, I believe, marked as Exhibit 5. I'm looking here, scrolling to the relevant time period. You see the entry for June 14th, Duke, where represents, would you agree, where Duke responded to Cherokee's request for information supporting his rates?
Yeah, Duke responded to it, but it didn't respond with any relevant information that would allow us to actually calculate its avoided cost rates.
I understand that's your position now, but can you point to any?
That was our position. I'm sorry, go ahead.
No, go ahead.
No, that was our position then.
And did you communicate that position to DEC or Mr. Keene?
Yes, verbally.
Okay. I'm looking at this timeline. The next entry after June 14th, which is, again, this is titled Petitioner's Timeline of Events, is March 9th, 2020. There's a gap of about 9 months there, saying that there's other communications in here that were not included in the timeline.
There was a phone call following this letter that we expressed our displeasure with the lack of information that they provided, which there's effectively zero relevant information here that would allow us to calculate Duke's avoided costs. So we were not able to receive that information until we received it as part of the discovery, as part of this proceeding. So there was that request, and it was communicated to us verbally by Mr. Keene that, well, we're just not going to disclose any of that information to you. So we are left without any options at that point to try to validate what their true avoided costs are.
Understood. I'm going to take you to the end of this document here. It's the certification. And if you would read for me starting after this semicolon where it says "and that."
You want me to read it?
If you would read to the end of that sentence.
To the best of my knowledge, information, and belief, all information contained therein is accurate and true and contains no false, fictitious, fraudulent, misleading statements, that no material, information, or fact has been knowingly omitted or misstated therein, and that all information contained therein has been prepared and presented in accordance with all applicable South Carolina general statutes, commission's rules and regulations, and applicable commission orders.
So fair to say that you are here certifying that you haven't omitted any material information from the timeline that was presented previous to this?
That's correct. I don't believe every phone call that was had between Mr. Keene and myself are detailed on this timeline. These are typically email and written communications back and forth. Yes.
So fair to say there was no formal written communication between June 14th, 2019 and March 9th, 2020, asking for additional information to support DEC's avoided cost rates, or otherwise indicating that Cherokee was not satisfied with the response it received.
That's correct, because we were told that Duke would not provide that.
Okay, I'd like to move on, if you'll bear with me. So I guess to dig into that just a bit more, I know you testified that you have had oral communications with Mr. Keene. If Cherokee thought that this response provided none of the information sought by Cherokee, did Cherokee ever engage with ORS prior to filing this complaint to attempt to resolve the dispute?
I don't recall if we did.
And would you have been involved in that discussion if it had taken place?
Either myself or not necessarily me, but someone else from our organization may have been involved.
But would
But
you?
I don't believe there was any formal communication with ORS directly by Cherokee.
Thank you. And are you aware that DEC and DEP had pending avoided cost cases that were filed at the end of 2018, updated after the passage of Act 62 in the spring of 2019, and then pending, I believe there was a hearing in the fall of 2019. So case pending from approximately end of November 2018 through the summer and fall of 2019.
I was aware of that, yes.
Mm-hmm. And Cherokee didn't intervene in either of those proceedings, isn't that right?
That's correct.
And because Cherokee didn't intervene in those proceedings, it didn't raise any concerns in the proceeding that that the rates and methodology that were being set by the commission were not appropriate for one reason or another.
Well, we didn't intervene in the proceedings. So.
Okay. All right. I'd like to move on to talk about the avoided cost rates that were circulated from DEP to Cherokee in June 2020. Do you recall when Cherokee first asked for information to support those June 2020 avoided cost rates?
I don't recall.
Okay, looking back at this timeline and looking at the next two entries, do you see the entry for July 20th, 2020?
Okay, yes.
And would you agree that this is the next time that Duke asked for information to support, that Cherokee asked for information to support DEP's avoided cost rates?
I believe that sounds correct, yes.
And scrolling down again, would you agree that, I'm looking at this entry for August 2020, would you agree that DEP responded to that request on August 2020?
Yes, they did. Yes.
And I'm going to show you what was pre-marked as Hansen Cross Exhibit 7, if I can find it. Yep, here it is. This is an August 20th, 2020 letter from Mr. Keene to Ms. Murph, and it was included in Mr. Keene's pre-filed direct Exhibit 2 and stipulated by the parties. Mr. Chairman, I'd ask that it be marked as the next hearing exhibit.
All right, I'm gonna wait until I get a copy of this in my hand. All right, so we have Hansen Cross Examination Exhibit 7, correct?
That's correct.
All right. Hansen Cross Examination Exhibit 7 will be marked and entered into the record as Hearing Exhibit 8.
Thank you, Mr. Chairman. So I'm just gonna scroll through this letter briefly, and I see, tell me if I'm wrong, would you agree that there is a response connected to each of the 10 questions that Cherokee had for DEP? Would you agree to that?
There is a response, yes.
And I'm going to, understanding your position today that that you disagree with the level of detail provided in these responses, did you communicate that in writing to DEP after receiving these rates in August 2020?
I don't believe we did respond in writing.
So, Mr. Hansen, we've just gone through, fair to say that we've talked about 2 requests for supporting information to support DEC and DEP's avoided cost rates. The one that Cherokee circulated in April of 2019, and then the one circulated in July of 2020. Those were the only 2 times in the 3-year time cycle that Cherokee requested supporting information. Isn't that right?
Well, I guess it's other than during discovery during this process.
Sure,
But
outside of.
Again, these responses are not responsive in a nature where we would be able to validate their Duke's avoided cost calculations. They also presume that they also ignore the establishment of our legally enforceable obligation in 2018, as the methodologies were approved in dockets beyond that point where we established our legally enforceable obligation. So, well, there is a response here that it's not complete enough for us to validate the avoided cost rates that were presented to Cherokee.
But notwithstanding that position, you agree that with respect to this letter from DEP, Cherokee never responded in writing to itemize the ways that it needed additional information and the questions that it felt that Duke did not appropriately respond to.
Not in writing, that is correct.
Okay. And so I guess over the last hour and a half or so, we've just gone through each of Cherokee's requests for DEC or DEP's avoided cost rates and each of Cherokee's requests for supporting information, and understanding that you may not have agreed with the responses, can you agree today that it's fair to say DEC and DEP responded timely to each of Cherokee's requests, whether it was for avoided cost rates or supporting information?
Well, I think by providing a written response is not necessarily responding. While they did send response letters, they were lacking the information necessary for us to complete what we were trying to complete. And frankly, that would have hopefully have led to transparent negotiations with Duke. We were unable to do that. So while they responded, I don't believe the responses were complete or met the level of obligation Duke had to be more responsive and provide the information we were looking for.
Understood, but fair to say, for example, when DEC asked for, or sorry, when Cherokee asked for DEC's avoided cost rates in the fall of 2018, Mr. Keene, on behalf of DEC, did in fact provide avoided cost rates that were calculated using the company's standard methodology based on rates that were current in 2018, correct?
Mr. Chairman.
I can't confirm that.
I heard
Mr. Chairman,
someone.
could I interpose?
Yes, could you please
Mr.
identify
Pringle,
your?
Jack Pringle. Yeah, Jack Pringle for Cherokee. It's certainly moved along some, and I've given Mr. Marco some leeway here, but I think Mr. Hansen has answered that question any number of times about whether it's for specific offers or specific responses. I think he's now answered those things numerous times.
Right. Counsel, for the Duke companies, could you pull your document down?
Yeah. Apologies for that, Mr. Chairman.
No problem. Do you have a response to Attorney Pringle's objection?
I can withdraw the question.
Okay, thank you.
And if you'll bear with me for 1 minute, Mr. Hansen, I think I may be checking my notes, but we're certainly close to finished here. All right, I have no further questions.
All right, Office of Regulatory Staff.
Thank you, Mr. Chairman. Real brief, I think most of my questions have already been asked and answered. Good morning, Mr. Hansen.
Good morning.
Could you tell me how many employees does Cherokee have?
The Cherokee facility employs approximately 15 people operating the power facility, and then our industrial facility that we support, the Ready Ice facility, employs, it's a lot more in the summer. It's on average 50 to 70 people on a year-round basis.
All right, thank you, Mr. Hansen. I have nothing further.
All right, thank you, ma'am. Commissioner questions?
Mr. Chairman.
Commissioner Powers?
Thank you, Mr. Chairman. Good morning, Mr. Hansen.
Morning, Commissioner.
I noticed you said you're not a lawyer, and I'll congratulate you on that, having spent 40-something years being a lawyer. You probably made a wise choice. But, you know, we're going through a lot of what I call he said, she said stuff, and what we're trying to do is move this forward. Who would be responsible for calculating the voided costs at the time that an LEO was established?
Typically, the utility off-taker would calculate those avoided costs at that point in time.
Well, and either we got a LEO or we got a brand new contract or brand new PPA. How could a LEO be established if both parties don't agree to a voided cost rate?
Well, the LEO establishes a point in time where the qualified facility can have the avoided cost calculated. And I think the other obligations under PURPA are to enter into good faith, transparent negotiations. Part of that good good faith, transparent negotiations piece has been able to, would allow us access to Duke's avoided cost information so we could validate those avoided costs. For example, in Duke's first offer to us, while they were going through the updated 2018 IRP, their letter indicated to us they didn't have a capacity need until 2028. When that case was resolved at the end of 2019 and early 2020, it turned out their capacity need was actually in 2026. So our position is, while there's an ongoing IRP case, that case isn't settled, and the prior IRP is the premise for the avoided cost rates up until the commission approves either a different methodology or different avoided cost rates or needs on a go-forward basis.
Well, you know, as a lawyer, I know a contract is considered a meeting of the minds. And, you know, in the last couple of years, we've been through an awful lot with COVID, with the economy, with all the administration changes, everything that we've been through. Why would it not make sense if we're talking about a new PPA to use current numbers and current methodologies in determining what rate we're going by? I mean, a lot of things have changed. I know I filled up my car the other day and it was right at $3 a gallon. Is there some reason that we shouldn't go as current as possible?
Not necessarily. I think that's an option, although that's not what PURPA obligates the utilities to provide. I think I agree with you, and I wish I could buy $3 gas in Connecticut where I am. But you know, part of the issue in our feeling here is the establishment of this legally enforceable obligation is designed to prevent a lot of the actions that we feel Duke has been taking to prevent these transparent negotiations to actually have us be able to enter into a new agreement. And that's why this kind of putting the stake in the ground allows the qualified facility to the rates available at that point in time to avoid the utility's ability to, frankly, almost never enter into a new agreement. So, I mean, that's a right under federal law, but I do agree with you that we have been through a lot. This facility is 86 megawatts. Duke's portfolio and winter resource needs is almost 32,000 megawatts. So less than it's about 0.25% of their resource portfolio. This is a very small facility. And maybe Mr. Strunk will talk about rates and stuff like that, but we're not looking for anything different other than what Duke's avoided costs are. So Duke's customers should be indifferent to the rates that we're paid. We're just trying to validate what those rates should have been when we established that gap.
Well, putting the stake in the ground, as you say, would Cherokee have accepted a 10-year PPA from Duke in 2018 under the IRP assumptions at that time?
I believe, as we calculated, yes.
Okay. Thank you, sir. That's all I have, Mr. Chairman.
Thank you.
Chairman Williams.
Commissioner Caston.
Good morning, Mr. Hanson.
Good morning, Chairman or Commissioner.
Well, you not give me that promotion.
I'm sorry.
No problem. I'm okay just as I am. Thank you. Does Cherokee or the parent company have in-house experts to evaluate, calculate, or whatever avoided costs?
We have in-house folks that work on rate schedules all the time. So we have people that could help us calculate that. We felt in this case, using our external witness who's been involved with these cases before would be beneficial for us, as while we calculate, our company owns transmission companies, so we calculate transmission rates for the most part as regulated transmission owners, but we don't calculate, we're not a utility by nature, so we don't calculate all-in customer rates on a retail basis as Duke would do.
So has your company evaluated or calculated other utilities' avoided costs in the past to verify them?
I believe we have evaluated them, yes.
All right. Did your company send a specific request, I guess with specific details? Like, in other words, clearly, it appears you don't concur, or your company doesn't concur with what Duke submitted, or the Duke companies submitted. Did you send, or any one of your companies send, specific detailed request or specific information that your company believed was absent from the submittals from the Duke companies?
Well, I think the requests in, we didn't send anything written. The request detailed specific information that we requested that was not provided again until we got to discovery as part of this case. But we did not send a follow-up formal request as we just went through in testimony.
So how would the Duke company know what to submit to answer your question if they don't know what the question is?
Well, I think the question and the request for information was very detailed. The response was really a response of methodology for the most part that didn't have the underlying specific fuel and energy price information, as well as information on Duke's portfolio, such that we could back calculate what we think Duke's avoided cost is at that point in
time. I'm trying to follow it, but you're saying that this information was requested, but it was requested in what form, or how was it requested again?
Well, at least in our view, it was very clear what we were requesting in terms of detailed information that we could use to calculate Duke's avoided costs. The response was lacking that detailed information. And in conversation following that, that's where I referenced in my testimony, just in a response to Mr. Marco's question, that Mr. Keene indicated to us that Duke would not provide that information. So we're kind of left with kind of outside trying to figure out what can we do next to try to enter into an agreement and validate this, these rates that Duke was offering.
So am I understanding you to say that in some form, the company Cherokee requested specific additional information from Duke or the Duke companies, and they said they would not provide that information, or they did not provide that information? Is that what I understood you to say?
That's correct. They would not.
And again, tell me one more time, because I'm not totally tracking it. In what form did the Cherokee request specific information of the Duke companies?
In the original request on April 30th, 2019, we requested specific information from DEC and DEP that was not provided. That would have allowed us, if we did receive that information, to validate the pricing that Duke provided in their responses to us.
And I certainly understand in any negotiations or anything doing, there will be emails, telephone confirmations, or calls, telephone calls and such. But is it typical of Cherokee to negotiate I guess I heard phone calls referenced a few times. Was there any timely written documentation of those phone calls other than the information presented in Cherokee's timeline?
No, I don't believe so. There may be emails that represent internal emails that kind of communicate what we heard or what was the outcome of a phone call, but I think most of the more formal communication is part of the record at this point.
Is it typical to respond? I noticed in one of those, there was that 9-month gap that I was trying to get my head around. Is it typical for Cherokee to respond via letter when a letter is received that has specific timeframes on them, requesting or due dates or whatever? Is that a typical response?
Yeah, I think after each of the, and I think those apply to the offers that had 60-day time limits on them. Following each of the receipt of both of those offers, there were phone calls with Duke expressing our displeasure in terms of what the rates were, requesting information and communicating why we felt the offer and the form of agreement that they're proposing were unworkable, especially given that they were written as take it or leave it offers. Here's the form of the contract, fill out your contact info, fill out a couple exhibits, and we'll send you an execution version. That's unworkable for a facility like this. And it's not how, it's just unworkable for a long-term agreement. So.
Well, after receiving those letters that Cherokee considered unworkable, is it typical or atypical of Cherokee to respond to those particular letters within a week, 2 weeks, 6 months, 9 months? I mean, what is the normal time frame of reaction?
Well, Cherokee's only negotiated 2 of these agreements previously. I think the last agreement, the negotiation went fairly quickly. So, and I wasn't involved in the original agreement, so I don't think there's any typical for Cherokee in this situation. But I believe there was communications via verbally that what was provided was not workable for Cherokee. There was not as evidenced by the communication, there was not written responses in each of those cases saying that.
And let me ask this then, maybe another way. Is it normal for Cherokee to not respond in writing within the time frame received in the letter from the electric utility, regardless of whether you agreed with the rate or the time frame? Is it normal for Cherokee not to respond within that time frame as established in the electric utility's letter?
I can't say what, I guess I could answer, would it have been more prudent for us to respond and to communicate that this was unworkable? I guess that would have been more prudent, I would say that.
Okay. One final thing is I was trying to understand, I guess, the Leo and time frame. If a qualifying utility, I guess, negotiates a 5-year or 10-year PPA or contract with an electrical utility, and say at the end of 2 years of the contract, QF desires to have a more favorable rate, can they submit a Leo to the electric utility and it be binding?
Well, look, again, I'm not a FERPA lawyer, but I believe once you enter into that contract, my view is we've entered into that contract for the term of the agreement. I think it's an election at the point in time whether you would agree to enter in a fixed long-term agreement or rates that may adjust over time. I believe that's an option available to the qualified facility, but our intent was to negotiate an agreement that would last 7-10 years, as we have in the past, and that we would be obligated pursuant to that agreement.
All right, thank you so much. I appreciate it, Mr. Hanson. You've been sitting there a long time.
Thank you, Commissioner.
Commissioner Thomas.
Thank you. All right, so Mr. Hanson, I just have a couple of questions. And the first one, maybe, I'm not an attorney and you're not an attorney, so this might be a real waste of time. But how can you have a Leo and then with Duke Carolinas, and then just a couple of weeks later you put another letter out there or offer or whatever it is with Duke DEP? If you're putting it out there for basically 100% of your capacity, then how can you have two legally enforceable obligations out there at the same time for 100% of your capacity to different entities?
Yeah, I think those Leos establish a stake in the ground for you to enter into an agreement with that utility. Again, as I said earlier on, we were directed to DEP because of their nearer term capacity need once we received Duke Energy Carolinas avoided cost rates that didn't include any capacity payments. So that's why we went in that direction. We were indifferent to which utility we sold Cherokee's output to. We would be glad to sell the full output to either DEP or DEC or prorate it, based on each of the utilities' needs. Clearly, DEP had nearer term needs. It was actually in the process of an RFP when we submitted that legally enforceable obligation to DEP. So really, we moved in that direction, really in an attempt to try to negotiate something that may be more attractive for Duke. that's why we went in that direction. But there's nothing I don't think that would prevent under PURPA us selling portions of the facility to either utility.
Okay. So, earlier today, you had indicated that you were not the point person on the negotiations, and I think I've seen that Ms. Murph was probably that person. Maybe I'm wrong about that. But why would she not be here available for us to speak with today?
But are you talking about the existing PPA, Commissioner?
Well, I'm talking about the negotiations that are going on that we're here talking about today. You said you were not the point person, and I believe Ms. Murph was the point person. So I'm asking, why isn't she here for us to talk with?
Well, let me clarify, Commissioner. I think what I was trying to communicate, probably did a poor job of it, was that during the negotiation of the current PPA that ran out at the end of last year, that was negotiated in 2012. I was not the point person. Ms. Murph was not the point person. There were other people within our company. One is still with the company, but they have not been involved. Those folks have not been involved in the current proceeding. I have been, at least in the last year and a half, the point person and interacting with primarily Mr. Keene at Duke on Cherokee's behalf.
So I think I just now heard you say that you are now the point person on these negotiations where we are today. But I mean, I see Ms. Murph's name on these letters as being the communications were going to her.
Right. She, as in her role from asset management, contractual letters are typically in our company signed by what we call our asset management group. She leads that group. And so she signed those letters. But I was involved with reviewing, preparing, and approving, sending those letters when they were sent.
Okay. So one final question. So we're here today and in this proceeding where it looks like we're the ones that are going to end up being able to make the decision on the contract terms. That's the way I see it anyway. So is it a waste of time for you and Duke to talk anymore? I mean, do you think it makes any sense for you all to continue to try to work this agreement out, or is it not going to ever happen under any circumstances? Just asking from your point of view as the person at Cherokee, do you think there is any possibility, if you continue to try to work this out, that you could work it out?
That's a good question. Look, we have always been open to try to negotiate a solution. We did go to mediation as ordered by the commission. That, in our opinion, fell very flat. Some of the precedents in terms of that we felt that we're lacking is their acknowledgement of our establishment of our legally enforceable obligation back in 2018. And that's the key issue in this proceeding, because it leads to what are the appropriate rates that Cherokee should be offered. So while I think Duke has, in their latest offers, at least in terms of willing to extend an agreement in the form that we're operating under right now, which I believe is beneficial to both parties. It allows them to utilize the resource as part of their operating portfolio and turn it on and off when they want. It runs quite a bit, probably 60% of the time. So while I'm hopeful, I would like to say we could give it another shot. I'm just I just don't think the approach that we've seen from Duke, we would be able to accomplish anything, to be honest.
Okay, thank you. That's all I had.
Thank you, Commissioner.
Mr. Hanson, I have a couple of questions for you before we break for lunch. Everyone has questions. What time is it? Let's take, you're on the stand, you're on direct. Well, at least your attorney put you up for direct. This is cross-examination, but you were instructed not to talk to anyone about your testimony while we're breaking for lunch. We're in recess until 1:15.
Thank you, Chairman.
Good afternoon, ladies and gentlemen. Welcome to the Public Service Commission of South Carolina. We're here in docket number 2022-63-E. Let's take roll before we get started. Present in the hearing room, we have Commissioners Powers, C. Williams, J. Williams, Belzer, and Thomas. And joining us virtually, we have Commissioners Caston and Urban. We were on Commissioner questions. Vice Chair Belzer.
Thank you, Mr. Chairman. Good afternoon, Mr. Hanson.
Good afternoon. How are you?
I'm fine, thank you. I'm just waiting for you to come up on the screen.
Okay.
There we are. Mr. Hanson, I believe in your summary, you indicated that you don't think that the 60-day time limit that Duke had in their response to your letter, to the Cherokee letters, purporting to be the LEO, you didn't think that the 60-day time limit is allowed under PURPA. Can you explain that conclusion to me?
Yeah, I just don't think under the federal statute there's any time limit with respect to call it the termination of a LEO. As I understand, PURPA provides for this legal, kind of the stake in the ground, which is called this legally enforceable obligation to commence a negotiation process. Part of that negotiation process is the sharing of information. And it was purposely designed as when PURPA was first put into place, as I understand it, and had been involved with historically. A lot of utilities were not very interested in entering into agreements with PURPA facilities in lieu of potentially building their own facilities. And so this establishment of a legally enforceable obligation creates that point in time where it will allow the parties to work through a process, whether it be an arduous process or fairly quickly negotiated process, to be able to come to a point where they're either going to enter into agreement or not. So I'm not familiar with, under the federal statute, any time limitations provided for under PURPA that would eliminate or extinguish that legally enforceable obligation.
Okay. Well, did the letter extinguish the LEO at the end of 60 days, or did the letter just indicate that the rates that were being given to Cherokee were good for 60 days? That after 60 days, those rates may have to be recalculated.
And that's exactly the point of the LEO. And as we've seen over the course of 2.5, 3 years now, with this back and forth between Duke and Cherokee, Duke has continued to recalculate those rates where the legally enforceable obligation obligates them to calculate those rates as of the point in time when they were established. The whole purpose of that is such that utilities couldn't implement delay tactics to prevent qualified facilities from entering into power purchase agreements under PURPA.
Okay. And is it Cherokee's position that Cherokee can establish a LEO with more than one utility for its output?
Yes, it is.
Okay. Thank you, Mr. Hanson. I appreciate your testimony. That's all I have, Mr. Chairman.
Commissioner Williams.
Thank you, Chairman Williams. Mr. Hanson, good afternoon. It's good to meet you and see you.
Good afternoon.
I'm going to follow up on Commissioner Thomas's line of questioning regarding kind of the fact that we're in this position where because you all have not been able to solve and negotiate a solution, that we're going to have to create our own. But several times you have talked about the fact that in the discovery data, you got information that you hadn't gotten until that time frame. Based on that, what recommendations, well, let me start with this question. Why wouldn't you want to go back to the negotiation table, given the information you now have that you were missing prior to the during the negotiation time frame?
Yeah, thank you for that. I think one of the parts that I struggle with, whether or not we think that would be successful or not, is at what point in time, now that we've received that information, would Duke calculate the avoided costs based on? Our opinion is they should calculate the avoided costs for Cherokee based on the time when we established our LEO. As we've seen over the course of the last several years, they continue to calculate the avoided costs as they progress through time, not respecting the establishment of that legally enforceable obligation. I think what I would say is, now that we have received that data, I think if Duke had calculated what we think the avoided cost calculation should be for the 10-year tolling agreement that they offered us in February, but based that on the avoided cost rates back when we established our legally enforceable obligation, I think that would result in a rate as calculated by our witness or our expert, Kurt Strunk. I think that would be at a rate that would be acceptable to us.
Okay, thank you. Changing gears, I want to focus on that the company is currently taking in rates based on the 2012 PPA. How do you propose that customers be made whole on any over or payment, if there is an overpayment difference, due to the extension of the contract terms?
Yeah, and I think the commission's order laid out that it would be our obligation to make them whole based on whatever the commission decides as an outcome of this proceeding. That could be done in many ways. That could be incorporated into the forward rate. It could be incorporated into some type of refund type mechanism. One thing I would point out, the rates that the current PPA rates is shaped. So most of the payments are in the middle of the summer, or the larger payments. So up to through this point in time, I don't think there is a huge difference in that. And then Duke and Cherokee have been in discussions around credit support to try to secure those obligations on a go-forward basis. Our hope is we can resolve, how we're going to proceed forward as part of this proceeding, and then we can determine how to, reimburse, if necessary, the customers based on what we've been paid to date at that point in time.
So I think, let me check and see if I got what you said, that you are, that up until now, because the shape of the rates is based more at peak usage time of the summer, that there's not, if there is any over collection, there hasn't been much, and that going forward, you would be looking at a bill credit.
That's right.
Okay. I think that's all. Thank you very much.
Thank you.
A few questions for you, sir. I think I understand what you're asking from the commission, but I just want to ask you a question in a very clear manner. What do you want us to do, or what do you think we should do?
Thank you, Chairman. I think as part of these qualified facility negotiations, I think it's very important for the commission to ensure that the utility are meeting its obligations with respect to negotiations with qualified facilities. We have a very specific case here with Cherokee, which I think I've outlined a couple times, how I think the commission, what would be a reasonable solution, and in meeting, and that would meet the obligations under PURPA. But we felt as part of this negotiation process, there was a lot of back and forth, information not provided to Cherokee to allow us to effectively negotiate, and various other items such as a contract with a take it or leave it message in the letter to us that doesn't rise to the level what we feel is good faith, transparent negotiations. I think other than with respect to the resolution of how we determine what is appropriate for Cherokee, which this case is trying to determine, I think it's also important to make sure the commission outlines for other QFs and what Duke's obligations are with respect to those negotiations with those counterparties.
Okay, so I'm still unclear as to what exactly you want us to do. I understand you all have been working on this for almost 3 years, which to me blows my mind. But I'll get to that in a second. You filed a complaint, and I read it. But I just in a sentence or two, what outcome are you seeking based on your complaint?
We're seeking to enter into a new PPA. I think what Duke offered in its last 2 offers, which is really a 10-year extension of the existing tolling arrangement based on rates that were in effect when we established our LEO in 2018, would be the appropriate resolution for this case.
Okay. All right. Thank you, sir. You answered my question. Now, you think that's appropriate. Why? Considering that it's 2021. Why is that appropriate?
Because PURPA provides for us to establish our legally enforceable obligation. Again, that sets the stake in the ground for rates to be calculated at that point in time based on when we've committed our units. And I'm not a PURPA lawyer, but I believe PURPA allows the qualified facility to select those rates or ongoing rates as can be recalculated over time for the period of service that we would supply to Duke in this case. You know, we think those rates calculated, and if it had been done appropriately back in 2018 in this manner, and we could have validated it, I think we wouldn't be sitting in front of the commission today.
Understood. Help me understand why you waited so long to file your complaint. And I could be wrong, but from what I see, you filed your complaint November 2020?
I believe that's correct.
Okay. And correct me if I'm wrong, this dispute, if you will, or the inability to reach an agreement arose in 2018. Is that correct?
The commencement of the process started in 2018, yes.
Right. But when did you've made a lot of allegations against Duke regarding not operating in good faith and so forth and so on. When did it come to your attention that you all were at an impasse?
Well, it came very clear in June. I think we had a couple back and forths in mid 2020 with respect to them offering us a form of agreement or rates in a form similar to what we're operating under today. And when we had a back and forth on those last 2 proposals, it became very clear to us that we weren't going to resolve this thing. We didn't want to file a complaint. I mean, we started this process hoping we could resolve this and put it behind us fairly quickly. We moved over to offer our capacity to Duke Energy Progress because they had a need, and we just never got there. And I think the core element of it is I don't think Duke ever respected the establishment of our legally enforceable obligation.
Okay, I've heard you talk a lot about the PPA that was entered into in 2012, I believe it was. And you may or may not be able to answer this question, but I'm just curious to know from your position, what has changed? Why were you able to enter into an agreement in 2012? And I think you all have been working with Duke since 1998 or so, if not longer. Like, what has changed? Why would it take almost 3 years of back and forth, several appearances before the commission for you all to reach a resolution? It seems as if something has happened here that maybe is not easily identifiable by the filings. Is there something going on that we're not seeing?
Well, I'm not sure I can answer that. All I know is that when that negotiation was going on, and back in 2012, it was around the time Duke, Carolinas, and Progress were merging. So I don't know if that had anything to do with it, but that might be a better question for Duke. We're not sure why we haven't been able to come to agreement here.
But you feel as if you've operated in good faith. You've made fair attempts to resolve this matter. That's how you feel based on what you've done up to this point.
I think we have, and I think we've put several offers on the table that are fairly close, if not on top of what we now are able to calculate is what that rate should have been calculated at back in 2018. That's part of the process.
Thank you, sir. No further questions. Any questions from commissioners?
Mr. Chairman, I have some follow-up questions, please, sir.
All right, Commissioner Irvin.
Thank you. It's good to have you with us this afternoon.
Thank you, Mr. Commissioner.
The Chairman asked you what changed. I guess one thing that changed is that avoided cost rates have come down over time. That would affect negotiations, I suppose. True?
Yeah, they could, and that's the point of establishing a LEO, is that those avoided cost rates are kind of set in stone at that point in time. But
That's
yes,
right.
Avoided cost rates apparently have come down. They also go up over time.
So just so we understand, and I'm not a purple lawyer either, but I've tried to do a little reading up on it since I knew this was coming up. As I understand it, FERC changed they revised their regulations in July 16 of 2020 by order number 872. You familiar with that?
Not intimately familiar, but I know there were some changes, yes.
Right. And some of these changes I think may be favorable to Cherokee. So just bear with me a minute. I'm going to ask you a few questions about it. These major revisions to the regulations concerning implementation of avoided cost rates and setting rates gave state commissions, state regulators, more authority to create rates that are fair and reasonable. Would you agree with that?
I think that was the intent of some of those changes.
Right. And so the order highlights the need to evolve FERC's regulations to encourage development of qualifying facilities, or QFs. And one of the changes that became effective 120 days after the final rule was published in the Federal Register was that the larger QS, which you qualify in that category, it gets some special treatment. Were you aware of that?
I'm not sure specifically what that refers to. But.
Well, for example, variable avoiding energy rates for QF sales under contracts or PPAs or LEOs were affected by the final rule. And the final rule gives state regulatory commissions like the Public Service Commission of South Carolina new flexibility to structure future avoided energy rates to compensate QFs at a variable or as available rate calculated at the time of delivery over the term of the contract. Does that sound reasonable?
I believe that is an option for large QS.
Right. And so my point is that this new flexibility that has been put into the regulations seems to be perhaps in your favor, as you have pointed out that you established a LEO. That's not really in dispute, is it?
I don't believe Duke has acknowledged that we established a LEO even up to this point.
Okay. Well, we'll ask them about that later. But one thing that interested me is that unlike renewable energy QF, solar, wind, geothermal, you have a dispatchable resource that you're generating, and you can do it 24/7, correct?
That's correct.
And so does the law give you any extra credit for that? The fact that you can meet the utilities needs at any time, regardless of whether the sun's shining or the wind's blowing, you're always, whatever you generate is always available to Duke, correct?
It is. I don't believe we get extra credit for that. I believe, however that is valued, should be valued as part of Duke's avoided cost calculations that they would be willing to offer. But there is more firmness and responsiveness to our unit versus many of the solar and wind QS for sure.
Well, are you aware whether Duke Energy Carolinas or Duke Energy Progress has established that they're going to need more capacity going forward?
I know as part of their resource planning process, they have designated needs out in the future for more firm resources.
Do you think that since you can provide those resources without having Duke have to go out and borrow money and build a new facility, do you think that's something that should be taken into consideration in your favor?
I do.
And so what your position is that you should be entitled to avoided cost rates at the time you establish your LEO, correct?
That's
during
correct.
During the life of the contract, correct?
It would be how Duke values what are the avoided costs for the facility from the point that we are going to serve under the contract. So they would calculate it on a forward basis.
I understand, but somehow the commission's got to adjust the period of time between the point in time where the LEO was formulated. And by the way, it's my understanding that LEO doesn't require a meeting of the minds. It's like an implied contract, which under the FERC regulations creates an obligation on the part of the utility. Is that your understanding?
That's correct.
So we've got to establish what the rate should have been. Since you all couldn't agree, we have to establish what the rate should have been from the effective date you established a LEO up to the present, correct?
I think we need to establish a rate, what the rate should have been starting in January of 2021 forward. Because that's when our old PPA ended.
When did you establish your LEO? Did you establish the LEO the same date?
No, in 2018, we established a LEO for the period of January 21 forward.
Okay. Okay, well, how do we establish the length of the PPA for that period?
Well, Duke was originally offering a 5-year term. They've now offered a 10-year term. We think either of those, I think, would be appropriate. We think a 10-year term is more appropriate, so we don't have to go through this again in front of the commission, hopefully. But you know, our consultant, Mr. Strunk, has actually calculated, now he's received the information that we've been requesting, has actually calculated what we think that PPA rate should have been back based on the LEO date.
Okay. And just to be clear, what do you contend the LEO date is?
It's in late 2018.
Okay. And so under FERC's regulations and precedent, as a QF, you had the right to unilaterally commit through a legally enforceable obligation or LEO to deliver all your capacity and energy to Duke over a specified term prior to you and Duke entering into a PPA. Is that your position?
That is correct.
And by establishing the LEO, Cherokee as a QF can also fix the utilities avoided cost to be paid to the QF as of the time the LEO is incurred. Is that correct?
As it should be calculated for the period that we are going to provide service as of the date we established the LEO. If that's what you meant, that's correct.
Correct. That's what I meant. Thank you, sir. I have no further questions.
Thank you, Commissioner.
All right, redirect.
Jack Pringle again on redirect for Cherokee. Mr. Hanson, there was a fair amount of discussion both with commissioners and on cross-examination about why you waited to file the complaint and the time period that elapsed after some of the events in this docket. When did Duke Energy Carolinas make its first written offer to Cherokee for a dispatchable tolling agreement with a 10-year term?
I believe it was in February of 21.
And you testified earlier that that Cherokee filed its complaint when? Roughly?
I believe it was in November of 2020.
So you received that written offer some months after the complaint was filed?
That's correct.
Okay. And you've already testified that the current, define dispatchable just very briefly again.
Our current agreement allows Duke to dispatch the Cherokee facility as it wants to, subject to basically the capabilities of the facility. So it allows Duke to turn it on and turn it off when they need it to meet their customers' needs. And as I've said, over the last 3 years, it's run about 60% of the hours each year. And so it's dispatched what I would say is a fairly high capacity.
And how is a dispatchable agreement different from a must-take agreement?
A must-take agreement is one where we would only be compensated for energy and or capacity if we deliver energy to the utility. So they're called kind of must run type of contracts or must take contracts, because we won't earn any money unless we run and deliver it to the off-taking utility. So in situations where, you know, it's mild weather, Duke doesn't need all the power, that has led at times to, you know, Duke probably would rather not take the power from the qualified facility. So that led to some, you know, changes in the original agreement. And I think that led to the dispatchable agreement that we have in place now, is because it's more efficient for both parties to ensure that the facility is delivering power to Duke when its customers need it, not all the time.
And when was the current PPA, when did that become effective?
I know it commenced, I think, on July 1, 2013. I don't know the effective date of the agreement.
Okay, but you've had it, what term was it?
Through the end, so July 1, 2013, I believe, through the end of 2020.
Okay, and what in the previous agreement, you've mentioned this, what kind of changes were made to the previous agreement to reflect a more dispatchable type arrangement?
There was a voluntary curtailment procedure negotiated where the parties could get together and turn the plant down or off at certain times, and still ensure that, you know, the parties were kept whole. In that situation, this would be a situation where, in a must-take contract, the facility would be selling power to Duke even though they didn't want to do it. So there would be an economic benefit to either taking less or no power from the facility, and then the parties would both benefit by not taking that power, and the customers would also. So,
do you recall when that curtailment arrangement you described went into effect?
I believe it was around 2001 that was negotiated.
Okay. And just to finalize this, and there's been some discussion about this, following your correspondence of September 27th of 2018 or September of 2018, indicating the willingness to offer energy and capacity to Duke Energy Carolinas, what kind of PPA did Duke Energy Carolinas offer in response in October of 2018?
It was a must-take form of agreement that looked very similar to what they have posted on the website for the solar offtake agreements, and I think that was the form of the agreement. It was also provided with direction in the letter that was provided with the rates that, you know, here's the form of the agreement, fill out a couple of exhibits, and then we'll give you an execution form. That did not seem to, even though they said they wanted to negotiate, there didn't seem like there was much appetite for negotiation as part of that offer.
Did Cherokee, what did Cherokee do in response to those particular proposals for must-take PPAs?
Well, we did talk with Duke following the receipt of the one from DEC, and that's where we were directed to, you know, to look at DEP because they had a near-term capacity need, and that's why we shifted over to try to see if we could get an agreement negotiated with DEP. When we received those rates, again, similar form of PPA, must take PPA was, I believe, provided with that. And then we requested for the backup information so we could try to independently validate the rates that they were providing to us.
Did you offer any correspondence to Duke Energy Carolinas or Duke Energy Progress that indicated that Cherokee would prefer to be in the dispatchable tolling agreement?
That's how we commenced our discussions with, why don't we just extend the existing PPA? Why are we going back to scratch? And so I think most of those communications were between myself and Mr. Keene. Ultimately, based on my testimony here, Duke did provide some rates associated with an assumption that we would extend the current form of the PPA. And but that is where we tried to start the discussions.
And this is the last question on this point. Did you convey in writing to Duke Energy Carolinas or Duke Energy Progress that you desired to be in a dispatchable tolling agreement like the current PPA?
We did. We actually made, I believe, several offers to them with a term sheet of here's what the rates would be pursuant to just extending the current form of the PPA, which would be the tolling agreement.
Okay. You got some questions about, maybe it was from Commissioner Caston, about the kinds of things that you were asking of Duke Energy Carolinas and Duke Energy Progress in terms of supporting or explaining or justifying avoided cost rates. Do you recall that discussion?
I do.
And you had a discussion with Ms. DeMarco and with commissioners about what the company's or Duke's responses were. Do you recall that?
I do.
Okay. I'll just put it this way. What was missing from those responses?
The details are what was missing. The details are fuel curves, resource plans, information on Duke's own facilities so we could replicate, as I understand their methodology, they try to determine avoided costs by including running their system dispatch with and without the Cherokee facility and looking at the difference. We can't replicate that without specific information on what curves they're using, what constraints they're using, what the resource mix is that they're assuming. And again, we're trying to do this from a period forward, which was when we first requested it, 2021, which of course we're now in, on a forward basis. So that's the type of specific information that we have not been able to obtain until recently.
Thank you very much, Mr. Hanson. That's all I have, Mr. Chairman.
Thank you, sir. Any other questions for this witness? All right, sir, you may step down.
Thank you, Mr. Chairman.
Attorney Pringle, please call your next witness.
Mr. Chairman, I believe that my recently pro-hoc colleague, Mr. DeGrandis, if pro-hoc is a word, is going to present Mr. Strunk.
Okay. And is Mr. Strunk testifying as an expert?
Mr. Chairman, he is certainly offering some opinions based upon his experience and his acumen and his background and his knowledge. I think Mr. DeGrandis can address that in presenting him and preparing him and offering him to the commission if that's the chairman's pleasure.
I'm fine either way. I just want to know whether or not he was being offered as an expert, and if so, if any of the parties objected.
Mr. Chairman, can you all hear me okay?
Loud and clear.
Right. Mr. Chairman, how about if I go through the introduction of Mr. Strunk, address his qualifications, and then we can determine if anyone has any objections. Is that
That's fine,
is that
sir.
all right to proceed?
That's fine. Go right ahead.
Thank you, Mr. Chairman. Does he get sworn in first?
Yes, sir.
Yes.
All right, sir, if you can raise your right hand for me, please. Do you swear the testimony you're about to give will be the truth, the whole truth, nothing but the truth?
I do.
Thank you.
Okay. Mr. Chairman, I will present Mr. Strunk. Mr. Strunk, please state your full name and business address for the record.
My name is Kurt G. Strunk. My business address is 1166 Avenue of the Americas, New York, New York, 10036.
And by whom are you employed and in what capacity?
I'm employed as a managing director of National Economic Research Associates, also known as NERA.
Please describe your responsibilities at NERA, Mr. Strunk, and particularly with regard to the types of issues and projects you've worked on that are relevant to this proceeding.
So I lead a group at NERA that provides utility advisory services. So we'll work with utilities as they contract for power generation from independent power producers. We'll design solicitations for new capacity, new generation capacity, or, you know, in some cases we might do REC solicitations. And over the course of my career, which began in the mid-1990s, I've dealt with a number of PURPA contracts and PURPA issues. In 1995, we were looking at, I performed a project where we analyzed sort of what had gone wrong with PURPA contracts, and one of the main conclusions was that they had been structured as must-take agreements and should have been structured wherever possible as dispatchable resources. I've testified on PURPA matters and on pricing and costing for utilities and rate making generally.
Mr.
Counsel,
Strunk, submitted.
excuse me, counsel.
Yes, yes, Mr. Chairman.
I'm sorry to interrupt you. Our live stream producers are sticklers about getting the perfect picture of those talking and those of us appearing virtually. I've been instructed that we're seeing the top of your head. If you could maybe lower your camera so we can see your face, sir.
Is that better?
Yes, sir. That's much better.
Okay, great, thank you. Yeah, on my screen, it looks like you could have seen my whole head, but evidently it wasn't working widestream. I will keep it at this level, but Mr. Chairman, if somehow that varies, please let me know, and I'll gladly adjust it. And Mr. Strunk, you also submitted an exhibit, a 40-page exhibit detailing your various projects in the energy industry. Isn't that correct?
Yes, that's my curriculum vitae.
Thank you. Now, have you caused to be pre-filed revised direct testimony dated May 3rd, 2021 in this proceeding, and the revised version was sent out on July 23rd, 2021, is that correct?
Yes, that's correct.
Yeah. And could you briefly describe why you refiled your May 3rd testimony on July 23?
So it's my understanding that the parties agreed that the data that I had selected to be confidential and was redacted in my original testimony was not confidential from the perspective of either Duke or Cherokee. As a result, the testimony was refiled, including all of the redacted information in unredacted form.
And did you make any other changes to your testimony other than unredacting information that was no longer confidential?
No, I did not.
And do you have any other additions, deletions, or changes to your pre-filed revised direct testimony at this time?
No, I do not.
And Mr. Strunk, if I asked you all the questions that appear in your pre-filed direct testimony, would your answers be the same as they appear therein?
Yes, they would.
Mr. Chairman, I would request that Mr. Strunk's pre-filed revised direct testimony be read into the record as if given orally from the stand.
Mr. Strunk's pre-filed direct testimony will be read into the record as if given orally from the stand.
Thank you, Mr. Chairman. Mr. Strunk, did you also attach an exhibit number 1 to your pre-filed direct testimony?
There was an appendix, if that's appendix, is that what you're referring to, or were you referring to my CV?
Let's mention both, Mr. Strunk. Describe the appendix and then just identify, since we already mentioned it, your CV that's attached as Exhibit 1.
Right. So I included an appendix which provides an explanation of the calculations I made in order to translate DEC's offer from October 2018 from a must-take energy payment framework to a dispatchable tolling agreement framework. And so that is the appendix. And then the exhibit is my curriculum vitae.
Thank you, Mr. Strunk. Mr. Chairman, I would ask that Mr. Strunk's pre-filed direct testimony appendix that he just described and his exhibit number 1 be marked for identification and entered into the record as the next hearing exhibit.
Okay, so would that be KGS1, the appendix, and his CV? That's how I see it.
That's correct, Your Honor.
Okay.
That's correct, Mr.
All right, sir.
Okay.
So KGS1, the appendix, and the witness's CV will be marked and entered into the record as a composite exhibit. It's here in Exhibit 9.
Thank you, Mr. Chairman. Mr. Strunk, have you prepared a brief oral summary of your pre-filed direct testimony?
Yes, I can provide an oral summary.
Please do so, Mr. Strunk.
So my direct testimony hits on 3 areas of relevance to the dispute before the commission. The first area I addressed is the intent of PURPA and the implementation of PURPA across the country. The second area I address is the form of contract, whether it should be a dispatchable tolling agreement or a must-take agreement as proposed by Duke Energy Carolinas in October 2018. And the third element of my direct testimony is to quantify for the commission what a reasonable rate would be in light of Cherokee's communication to Duke Energy Carolinas in September 2018, where it elected to put its capacity to DEC at that time. So I'll address first the policy intent of PURPA, and in my testimony, I described that PURPA is designed to encourage qualifying facilities, cogeneration, and small power production. Cherokee is a cogenerator and is a qualifying facility under PURPA. PURPA, through the implementation and implementing regulations of FERC and how it's been implemented across the country by state commissions, allows a QF to displace capacity that would have otherwise been built or contracted by the host utility. And it does so at avoided cost pricing in order to assure that the host utilities ratepayers are indifferent to whether that capacity comes from a QF or from the utility. And important to the whole regulatory framework for QFs is this notion of a LEO. And as I present my summary, I will repeat a few key points that were made by Commissioner Irvin in his cross-examination or his questioning of Mr. Hansen. And the key points that are very relevant to this dispute are the fact that the LEO sets that stake in the ground, and it sets the date upon which the forecast avoided costs must be made. And what that does is it protects the QF. It protects the QF from delay tactics from a host utility. If the utility is not negotiating in good faith or is delaying the signing of a contract, it provides the utility the QF with that stake in the ground and assures that whatever the forecast avoided costs were at that time, that will be the rate that would be applicable to any subsequent contract entered into by the QF. So that's very important, and doing that, allowing for a LEO and a forecast avoided cost is essential to allowing for QF capacity to displace utility resources. If there were no advanced contracting under PURPA, if the QF were obliged to wait until the time of delivery, then the host utility would always go out and fill its capacity needs, and it could always, at a time of delivery, say, you know what, QF, I've already filled that capacity need. So that's why it's important that the LEO is set well in advance, or can be set well in advance, and can lock in an avoided cost forecast and provide a viable opportunity for QFs to displace the utility-owned generation. So those are the general intents of PURPA and the implementation. As for the second topic covered in my direct testimony, the form of contract, the Commission has heard from Mr. Hansen on this subject, but my testimony also addresses the unreasonableness of the must-take agreement that was put forth by Duke Energy Carolinas in October 2018 and was given to Cherokee. The parties had been operating for 20 years under dispatchable agreements to lock in a must-take agreement would have set Duke back and and harmed its ratepayers because it would have introduced inefficiencies in the dispatching of Cherokee. Under the existing PPA, which is structured as a tolling agreement, there are many advantages, and those many advantages lead to ratepayer benefits where Duke controls and can optimize the use of Cherokee on behalf of its customers. The third topic is the PPA pricing. As I mentioned, my direct testimony provides a rate, which, given the information knowable as of October 2018, would be the forecast avoided rate for the period beginning on January 2021. I'm sorry, January 2021, when Cherokee intended to sell the output of its facility to DEC under a new or extended PPA. So based on the information that I've reviewed, it was unreasonable at that time for Duke Energy Carolinas not to provide Cherokee with a capacity payment. And when I put together the information that was available, I used the most recent authorized avoided capacity cost for Duke Energy Carolinas, authorized by this commission. And I combine that with Duke Energy's avoided cost estimate for energy, which it provided to Cherokee in October 2018. And combining those two components, because Cherokee is providing both capacity and energy and should be compensated both for both products, I combine those two elements to get $110 per kilowatt year, inclusive of start cost, assuming a tolling arrangement that tracks the existing agreement. And that concludes the summary of my direct testimony.
Thank you, Mr. Strunk. Mr. Strunk, please answer any questions the parties or the commissioners may have. Mr. Chairman, we hear Cherokee Cogeneration Partners hereby tender the witness, Mr. Kurt Strunk, for questioning by the parties and the commissioners.
Thank you, sir. Mr. Strunk, I think a portion of the last sentence or two of your testimony faded out. So I don't know if you were reading from a document or not, but if you could just repeat your last two sentences for us, sir.
Yes, Mr. Chair, thank you for pointing that out. I was not reading from a document, but in the last two sentences, I testified that the reasonable rate as of October 2018 was $110 per kW kilowatt year, and that assumes an extension of the form of contract that Cherokee currently has with DEC.
Thank you, sir. All right, cross-examination. Duke.
Thank you, Mr. Chairman. Good afternoon, Mr. Strunk. Brett Bryceward on behalf of the Duke companies. Can you hear me okay?
Yes, I can. Good afternoon, Council.
Good afternoon. So just a couple of questions of your background first to recap. You're a managing director at NERA, is that correct?
That is correct, yes.
And your business address is in New York City, New York, correct?
That's correct.
And is that the headquarters for NERA?
Yes, at one point we were in White Plains. I believe the headquarters is now New York City, but the headquarters is in the state of New York, yes.
Okay. And have you ever testified before the Public Service Commission of South Carolina before?
No, I have testified before the NCUC, but not before the South Carolina Commission, no.
Okay, and when did you testify before the NCUC, which for the record is the North Carolina Utilities Commission, is that correct?
Yes, that's correct.
And when was that testimony provided?
It was a few years ago. It's in my CV. I would say it was probably in the 2017 timeframe. That would be my best guess.
And that was an avoided cost case?
That's correct, yes.
Right. Have you ever been to the Cherokee Cogeneration facility, sir?
I have not visited the facility, no.
Okay. And on page 1 of your testimony, you state at line 13 that you're submitting testimony on behalf of Cherokee County Cogeneration Partners, LLC. Is that correct?
That's correct, yes.
And did the LLC, Cherokee County Cogeneration, retain you to testify, or did its parent company, LS Power, who Mr. Hansen is employed by, retain you to testify here today?
I believe that it was LS Power, the parent company, that retained me.
Okay. And when were you retained by LS Power? Just approximately.
I would say a month or two before the filing of the testimony, probably 2 months before the filing of the testimony. So that would be
Spring 2021.
Yes,
Was it after the mediation was held? Do you recall?
I believe so. Yes,
Okay, so after the complaint was filed by Cherokee and LS Power.
that's my understanding.
And is it accurate that you testified multiple occasions for LS Power before?
No, I testified in one docket for LS Power in a PJM capacity market issue, but it was a single docket. I believe there were both direct and rebuttal testimonies. So if that's what you mean by multiple, then the answer is yes.
Okay, fair enough. So with that, at least one prior representation of LS Power, are you generally familiar with the company's business?
Generally, yes.
And would you say that LS Power is a sophisticated player in the wholesale power markets?
That's a fair characterization, yes.
Okay, so a large developer, owner, operator of power plants throughout the United States, I think as Mr. Hansen testified before.
Yes.
Okay. Turning to page 3 of your testimony, on line 14, you're speaking to the purposes of your testimony, and you say that the first purpose is to explain the economic and policy goals of PURPA and the instant dispute before the commission. And then later in your testimony, you kind of anchor back to that as the economic intent of PURPA. And is that because you're an economist and not an attorney?
Right. So I can speak to PURPA as an economist and as a regulatory and economist and also looking at wholesale power contracts. But yes, from the economic perspective, I'm not an attorney now.
Okay, and so you're not testifying to the legal requirements of PURPA as you're not an attorney, is that right?
I'm testifying to my understanding of the legal requirements of PURPA based on my experience in the industry.
All right, fair enough. All right, I'd like to move on to page 10 of your testimony, if I could, please, sir. Let me know when you're there.
Yes, I'm with you.
Okay. And so this section of your testimony, you are speaking to the PURPA framework for providing payments for avoided capacity costs and avoided energy costs. Is that correct?
That's correct. That starts on line 3 of page 10. Yes.
Okay. And I'd like to specifically focus for a little while on your question 14 that starts on line 13. You see that?
I do.
Okay. And so when you were evaluating, you were retained by LS Power to evaluate the avoided cost rates and offers that Duke Energy Carolinas and Duke Energy Progress provided to Cherokee over the past 2.5 years. You started your investigation by assessing how this Public Service Commission that's responsible for implementing PURPA in South Carolina had done so during the relevant time period. Is that fair?
Well, this answer includes some information that was not available at the time that Cherokee put its power to Duke Energy Carolinas. But I do provide the context. I do look at how the commission has addressed those elements in past orders. Yes.
Okay, so what would you characterize the relevant time period that the commission should be thinking about here in terms of the negotiations and the relationship, let's say, between Cherokee and DEC and DEP?
So my focus has really been on the DEC October 2018 offer, and that's because that was the offer that DEC made in response to Cherokee's notice to DEC in September 2018, where it communicated its intent to put its energy and capacity to DEC. So to me, that's the most relevant date. But I did look at the subsequent offers because I believe they're very revealing in showing how DEC has consistently ignored that initial LEO and has consistently treated this facility, which is providing reliable dispatchable capacity, as an intermittent resource. And so I reviewed the subsequent offers to understand how DEC's negotiation position evolved over time.
Okay, and I don't want to go too far down this path, but just to be clear, the methodology and avoided cost rates that DEC has provided to Cherokee, as well as the rates that DEP have provided to Cherokee, are not intermittent resource avoided cost rates. They're reflective of the avoided cost rates that Duke has provided on behalf of DEC and DEP to all QFs. Would you agree with that?
I can't state whether or not DEC provided those to all QFs, but I understand that DEC does have a methodology where they put in 100 megawatts of QF energy on a must-take into their ProSim model, and they update and they sort of look at the avoided costs based on that increment of new QF capacity. So I understand that there's a general method that this did follow, but it's a method that is more appropriate for a must-take resource.
Okay, all right. So returning back to your question 14, this question and answer is focused on whether utilities, specifically DEC and DEP, offer avoided capacity cost compensation in South Carolina. Is that the focus of this question?
Yes, it is.
Okay, and you, based on your review, you say yes, and the standard offer QF contracts corresponding to DEC's schedule PP rate incorporate compensation for avoided capacity costs. Did I read that correctly?
Yes, and that was based on the order number 2016-349.
Okay, we'll get that in a minute. But first, it seems like you also reviewed DEC's standard offer schedule PP that was in effect, let's say in October 2018 and prior. Is that part of your analysis?
Yes, it is.
And that's what you're referencing in line 15 there, correct?
That's correct, yes.
And just generally speaking, what is the standard offer?
So the standard offer is a rate and a set of terms and conditions that are available to small QFs under the scheduled PPA rate.
And is it your understanding that a standard offer is actually required by PURPA and FERC's regulations implementing PURPA?
I don't have a.
That's all right.
Yes, I believe it is. Yes, I believe it is.
Let's just be precise in that belief. And Mr. Chairman, I'm not intending to put this into the record, but I do have a few statutes and regulations which the commission can obtain from publicly available sources, and I'm sure counsel for Cherokee is familiar with these. So, Mr. Strunk, as a expert on PURPA, are you familiar with 18 CFR 292-304?
Yes.
And would you say this is the regulation that is central to why we're here today? This is the regulation that establishes the overarching framework that Duke must use in the rates for purchases that DEC or DEP must make from QFs. And can you see that all right? I can make it bigger there if that's helpful.
If you would, counsel, if you would zoom in on the document. Yes, sir. Thank you.
Mr. Strunk, would you agree with that based on your general understanding of PURPA?
Yeah, that looks like the right chapter of the code.
Okay, and this is kind of for us PURPA lawyers, this is where we live, so to speak. This is the central regulatory framework that established the rates for purchase by QFs. Do you agree with that? Not being a purple lawyer yourself, but just generally apparently being an expert on the topic.
Yes, that's a fair characterization.
Okay, and so subsection A says rates have to be just and reasonable to customers in the public interest and not discriminatory against QFs. That's kind of the fundamentals of PURPA that I think is in your testimony, as well as Ms. Bowman's and Mr. Snyder's testimony on Duke. These are the kind of the foundational principles of PURPA, right?
Yes.
Okay. And I'm sorry, please stop me if I'm moving too quickly here, but to circle back to our discussion of the standard offer, and just to make sure the record's clear, there's subsection C of 292.304, which provides there shall be put into effect a standard offer for QFs 100 kW or less. Is that your understanding of the regulations?
Right, and the practice by Duke, I believe, is to use less than 2 megawatts, but the statute says 100 kilowatts, yes.
Absolutely. And so that is this section here, that there may be put into effect standard rates for purchases from QS for the design capacity of more than 100 kW. Would you agree with that?
Yes.
And so generally speaking, the intent of the standard offer is to simplify PURPA implementation for small, unsophisticated QFs and to allow them to balance kind of the cost of negotiations with the utility and the burdens that would impose with the risk to customers that having a fixed rate based on a tariff that's not updated very often would become inaccurate over time. Do you think that's a fair characterization of why the standard offer exists?
So there was a lot in that question, Council, and I agree with a good bit of it. But if you were to unpack it, I could go through each component and
Sure.
tell you what I agree with and what I don't agree with.
Absolutely. So the standard offer under PURPA is intended for small QFs. We agree on that?
Yes.
And the policy objective behind having a standard offer that's available to small QFs but not large QFs is because the cost and expense of negotiation is something that PURPA didn't want, or FERC in implementing the regulations felt would be unduly burdensome to put onto small QFs. Is that fair?
Yes, and so that was really the only area where I didn't agree with your characterization, because I didn't think it was necessarily the case that those small QFs would be unsophisticated as you had referred to them, but the way you've recharacterized that, I'm comfortable with it.
Fair enough. And so the important point on the other side of the equation is that by having a standardized tariff avoided cost rates that's not updated very often, it creates greater risk for the customers that have to pay for those avoided costs from QFs, that they will become increasingly inaccurate over time. Do you agree with that?
Not necessarily. You can look at an avoided cost forecast at any point in time, and it could be above or below what it actually turns out to be, and it may be that something that's not updated and looks to be out of the money temporarily may come back into the money as markets move. So it's not clear to me that having a lack of update is going to necessarily on an ex-ante expected value basis have a necessarily a disadvantage.
Mr. Strunk, I don't want to quibble with you, but isn't that what you said your initial assignments with PURPA were in the 1990s, was to recognize and to try to mitigate the risk of longer term fixed price contracts that don't change over time, and that's why you suggested that a dispatchable PPA construct was more appropriate and better for customers than a must-take type of agreement? Wasn't that your testimony that you volunteered in your summary?
So yes, I testify that we worked to restructure some of those contracts and make them dispatchable, and certainly it's true that they can go out of the money and become stale. So if that's what the question is designed to establish, I'll acknowledge that, yes.
All right, very good. And so here's another one I think we can establish is that Cherokee at 98 megawatt nameplate is not available either, or not eligible, excuse me, for the standard offer either under FERC's regulations or under the Schedule PP standard offer implemented by Duke. Would you agree with that?
Yes.
Okay, so at 98 megawatts, it's essentially 50 times larger than the largest small QF that would be eligible for DEC or DEP Schedule PP, correct?
Yes, I just note that the contract capacity under the existing PPA is 86 megawatts, but you're right that it does operate to a higher level.
We'll call it 43 times larger if that is more accurate. All right. And would you agree that Cherokee has a 98 megawatt nameplate or 86 megawatt contract capacity facility should not be treated more favorably than standard offer small power producer QFs in the calculation of DEC's avoided cost rates?
Yeah, I think that's a fair statement, yes.
Okay. And would you agree that Cherokee has a 98 megawatt cogeneration facility with an 86 megawatt contract capacity should not be treated more favorably than other large QFs in the calculation of avoided cost rates?
Yes.
Okay. All right. I want to turn back to your testimony, please. You mentioned that you had looked at both the 2016 order 349 as well as in the first sentence on line 16 to 18, you reference order 2019-881.
Yes.
Okay. And what is order 2019-881?
So that was the outcome of the most recent avoided cost docket, and at that point, the South Carolina Commission was responding to the Energy Freedom Act, and there were a lot of issues that the Commission had to deal with as a result of the Energy Freedom Act, and so that is the Commission's resolution of those issues and avoided cost issues at the end of 2019.
Okay, so is it fair to say that was the first order issued under the Energy Freedom Act and the PURPA provisions of what we call Act 62 to implement PURPA in South Carolina?
That's my understanding, yep.
Okay, and did you review Act 62's PURPA provisions as part of developing your testimony?
So, you know, Act 62 came after the commitment by Cherokee to put its capacity to DEC. So it didn't drive my conclusions, but I think at one point I may have looked at it.
Okay, well, I just would like to look at it briefly if we could here, just to make sure we're on the same page about what was required. All right, I will, this is section 5841-20, which is review and approval proceedings for electric utilities avoided cost methodology, standard offers, form contracts, commitment to sell forms. You scroll down to the very end, the history. This was enacted in 2019 as part of Act 62, effective May 16th, 2019. And I'll submit to you that this is the section of the South Carolina Code that implements PURPA for predominantly small power producers and is the genesis, so to speak, of the proceeding that in the order 881 that you referenced in your testimony. Would you agree with that?
Council, I don't know if you were intending to share your screen, but I didn't see any of the document you were referring to.
Well, that is not effective. I guess I have to hit the share button. All right, let's try that again. Okay, let me make it bigger so I stay out of trouble with the chairman. Can you read that there, sir?
Yes, I can. Thank you.
Okay, so this is section 5841-20 of the South Carolina Code. As I tried to demonstrate for you earlier. If you scroll to the end and look at the history, it was enacted by 2019 Act 62, which I think you referred to as the Energy Freedom Act, effective May 16th of 2019. So would you accept, or do you know whether this is the statutory section that the companies had to file their avoided cost rates under as part of implementing Act 62?
That I have no reason to doubt that is the case. Looks like
Okay.
a document.
And would you agree with me that Act 62 required the commission to perform a detailed review and approve the standard offer tariffs for DEC and DEP, as well as the methodology that DEC and DEP used for calculating avoided cost rates?
Yeah.
Okay, and that's this language here that they undertook that requirement. And would you also agree with me that in implementing PURPA under Act 62, the General Assembly was explicit that the Commission shall approve avoided cost rates and methodologies that meet the requirements of PURPA and are consistent with PURPA and FERC's implementing regulations and orders? Do you agree with that?
That's what's on the screen. You've highlighted it. Yep.
Very good. So assuming then that the Commission reviewed that language and applied it, the Order 2019-881A that approved the methodology and the standard offer rates is consistent with PURPA and FERC's implementing regulations and orders. That logically follow?
It would, as I mentioned before, this is all after Cherokee had decided to put its energy to and capacity to DEC. So, yes.
Council, I think opposing counsel has an objection they would like to place on the record.
Mr. Chairman, I'd like to place an objection to record of where he's seemed to be asking for a straight up legal opinion on state law. And so I would object to the extent that Mr. Brasworth is asking for a legal opinion on state law in this, in with response to his question.
Attorney Brasworth.
I'm asking the witness in his review of order number 2019-881A whether he reviewed the statutory framework that informed that order and is familiar with the requirements of implementing PURPA in South Carolina, which, as we started at the outset, he asserts as an economist, albeit not as an attorney, he is presenting opinions about the implementation of PURPA, which this statute informs PURPA implementation in South Carolina.
Overruled. Please proceed.
Thank you.
So yes, as I said before, you know, my analysis was really focused on the late 2018 timeframe, where the date that Cherokee put its capacity to DC. But everything you've said to me regarding this document is supported by the document itself, and I have no reason to believe that the document isn't what you say it is, and it looks to be the Energy Freedom Act, or Act 62, as you say it is. So I don't doubt it, and the text in it is pretty straightforward. So
okay, good. Moving along then, are you aware that under Act 62, the General Assembly provided for the Commission to retain an independent third-party consultant to evaluate DEC and DEP's methodology for calculating avoided costs and to opine on whether that methodology and the rate proposals derived therefrom were consistent with PURPA?
is there a point in this document that makes that statement, if there is?
There is. I can point you to subsection I.
Yep.
It doesn't sound like you were aware that that in fact occurred, or that informed your analysis. Is that correct?
As I said, my focus was on what were the applicable regulations and what was known and knowable as of September, October of 2018, when when Cherokee put its, in September, when Cherokee put its capacity to DEC, and in October, when DEC came back with an avoided cost offer. I didn't put a lot of focus on what happened after that. The intent of PURPA is to allow a QF to have a legally enforceable obligation that sets avoided cost rates at that time. It's true that a lot of developments in the state of South Carolina did happen after that time, and I'm generally aware of it, but if you ask me about the details, I won't know every single detail now.
Fair enough, and I'm not asking you to know every single detail, but are you aware that this initial Act 62 proceeding and the order you cite in your testimony, 2019-881, is the first time the commission investigated in detail the methodology that the companies used to implement the avoided cost provisions in South Carolina, or to implement PURPA in South Carolina in establishing their avoided cost rates?
So the other order I cite was the 2016-349 order, and that was a settlement. So there was no detailed analysis of the methodology. I don't know if you go back in that 1995 docket, whether you're going to find a commission review of the methodology, but certainly it was the most recent review of the methodology.
And just to be clear, I think you said that the 2016 order you referenced, the commission did not perform a detailed review of the company's avoided cost methodology. Is that correct?
Yes, that was a settlement. That's correct.
Okay. All right. So you cite to order 2019-881A in your testimony, and I'd like to briefly focus on that if we could. Can I infer, since the fact that you cited in your testimony and you represented that the commission allowed for levelized payments to reflect value of any needed capacity that could be avoided in future years, you drew conclusions based on this order that you reviewed it?
Yes, and I reviewed it specifically looking at that issue.
Okay.
Of avoided capacity costs.
So you reviewed it looking at the issue of avoided capacity and developing your testimony. Did you also review it, or are you aware of the period of time that these rates approved in this order apply to? Or I'm sorry, let me take a step back and establish more of a foundation. So I put up on the screen here, and Mr. Chairman, this is a order that I think is well known to the commission and is publicly available on the DMS website. So I'm not going to seek to have it introduced as an exhibit, but I do have some questions based on the fact that the witness reviewed it in their testimony. Are you able to see the exhibit I have that I'm sharing here?
Yes, I see that.
I see you're squinting a little bit. I'm trying to make it big enough so you can see, but small enough to be usable. So this is 2019.
I appreciate that.
Understood. All right. So this is the very end of the order where the commission issues its final orders and conclusions, approved avoided cost rates and methodology after 160 some odd pages before that, fully investigating the company's avoided cost rates and methodology. And it says that the standard offer tariffs shall become effective November 30th of 2018 and shall remain in effect until the date the commission approves updated avoided cost rates. Do you see that language?
Yeah, I see that language.
Do you know why the commission in this order made the rates effective November 30th of 2018?
I don't, but the other thing that I'm looking at is 2019-881A, I was under the impression that there was a decision on the 31st of December of 2019.
You are correct, sir. The 881A, and maybe this is, I'm not sure how to represent this to you, but subject to check, would you agree that the December 31st of 2019, the commission issued order 2019-881, and then on January 2nd of 2020, 2 days later, there was a scrivener's error or something that they corrected, and this is in substance the same order for our purposes. It's just has a correction that was made between the original order and the sub A order.
That's helpful. Thank you.
You're welcome. All right, so returning to page 169, focusing on the effective date of these, and this is just very big. Standard offer tariffs approved by the commission effective November 30th of 2018. So this would be the schedule PP that you reviewed in your testimony. You know why they became effective November 30th of 2018?
Not off the top of my head now.
Okay, and you mentioned the 1995 docket a few moments ago. Can you tell us what 1995 1192E is?
It's my understanding that that was the docket under which the commission previously reviewed avoided cost filings and avoided cost rates up until I don't know if it was perhaps the establishment of this new docket.
Okay.
But for a number of years, it was the docket that was used by the commission to look at avoided costs.
Thank you. And did you review that docket?
I reviewed recent decisions.
Okay. All right. Well, Mr. Chairman, I'd like to introduce as an exhibit that's been pre-marked as Strunk Cross Exhibit E3, if I could, please, sir.
Strunk Cross Exhibit 3 will be marked and entered into the record as hearing Exhibit 10.
Thank you, sir. Mr. Strunk, this document that I've presented to you, the caption on it is 1995-1192E. That's the docket we were just speaking about, correct?
That's correct.
Okay. And the application is to update standard offer avoided cost rates and tariffs for the Duke companies DEC and DEP. You agree with that?
Yep.
Okay, and I'm not sure if you can see it. It's sideways on your screen there, but that it was filed November 30th of 2018.
I see that.
Okay, and so this have you reviewed this application before?
I believe so, yes.
Okay, and so this is the company's application to update their avoided cost rates filed November 30th of 2018, and specifically the standard offer that the companies presented in Schedule PP, which you referenced in your testimony, correct?
That's correct.
Okay, and so it says that Schedule PP will continue to be available at QFs up to 2 megawatts in size, and the companies will continue to offer previously available variable 5-year and 10-year term options. See that?
I do.
Okay, and so would you agree with me that the structure of Schedule PP, the standard offer, is not changing at this point in time?
There are more details to it, but I don't believe there were any changes to the structure of it. But.
Okay, well, let's talk about some of those details if we could. So one of the important details between your testimony and the company's testimony is the appropriate methodology for calculating avoided capacity. Would you agree with that?
Yes.
And so your position is that you reviewed the standard offer applicable to QFs up to 2 megawatts, and that informed the calculations that you performed to recommend avoided cost rates for the 98 megawatt Cherokee Cogeneration facility. Is that correct?
That's right. That was the latest commission authorized avoided cost, capacity cost that was in the public domain.
Okay, and so would you agree, let me go through this language first and then ask that question. So would you agree with me that the intent of this section is to describe the methodology the companies use to calculate their avoided or avoidable capacity under the Peaker methodology, which is the methodology the companies use to quantify their avoided capacity costs? Sorry.
Yep.
Okay. And so I'm just going to read it to you. It says, in quantifying DEC's and DEP's future avoidable capacity under the Peaker methodology, the companies have recognized their first avoidable capacity need in the year that each utility's most recent integrated resource plan next demonstrates an avoidable capacity need. Pursuant to the company's 2018 IRPs, DEC's next avoidable capacity need is a planned 460 megawatt winter rating of combustion turbine capacity in 2028, while DEP's next avoidable capacity need is a 30 megawatt short-term capacity purchase in 2020. Did I read that correctly?
Yes, you did.
Okay. So as of November 30th, for standard offer QFs 2 megawatts or less, the companies were seeking for the commission to update their avoided capacity calculation to reflect the first year of need in specific to DEC, the 2018 IRP, which was in the year 2028. Is that accurate?
So I addressed this in my rebuttal testimony. That was the company's position. There were a lot of interveners that didn't agree with the company's position. There was no determination by the commission at this stage, and this document even postdates the Leo that Mr. Hansen referred to and is evident from the Cherokee September 2018 letter.
To be clear, the Leo you're referencing is one of the most contested issues in this proceeding between Duke and Cherokee, correct?
That's correct. And it is the QF's option to establish a Leo. It's not Duke's option. So
understood. And you would agree that's based on the QF's conduct, which it's this commission's responsibility to assess that conduct and make a determination of whether the QF actually created a legally enforceable commitment to sell and deliver its power to the utility for a future specified term under PURPA.
We're completely aligned in our understanding. It's the commission's decision.
Excellent. All right, we can move on from there. All right, so returning to this, at least would you agree with me, sir, that as of November 30th, when DEC and DEP filed this application, they were asking the commission to update their standard offer tariffs for small QFs to establish that the avoided capacity rates for those very small projects would be calculated based on a first year of need of 2028, based on their 2018 IRP information.
For DEC, that's right. Yep.
Okay. And really, your analysis and focus is on DEC, correct? You didn't do any economic analysis or rate calculations for DEP because Cherokee never sought to obtain transmission to deliver the power there, so it's kind of anecdotal.
Yeah, Your Honor, objection to the extent Mr. Counsel's kind of testifying as to why Cherokee did or did not submit. I think the first part of his question is fine.
Sustained.
I'll withdraw the second part of the question.
Okay.
Could you kindly repeat the first part?
Yes, sir. So your analysis of the $110 that you say is an appropriate rate, that's specific to DEC. You didn't do any rate calculations or analysis as it applied to the avoided costs for DEP at any point in time, correct?
That's right. I did look at the offers, but I did not do any economic analysis of rates for DEP, no.
Okay, and consistent with the testimony this morning that there was a earlier capacity need for DEP in 2020 versus DEC in 2028, that's reflected here in the application that the Duke companies filed with the commission for approval for standard offer QFs. Would you agree with that?
Yes, that's right.
Okay. All right. All right, so I'd like to return to your testimony, if I could, on page 10, referring to Order 2018-881A, if we could, please.
I'm on page 10. I'm with you. Thank you.
Okay, line 16 and 17, you reference levelized payments to QS for avoided capacity. Can you explain what you mean by the term levelized payment?
Right. And so as it was proposed by Duke, the levelized payment would take into account the fact that in some years during the QF's contract term, the utility may not need capacity, and in others, the utility would need capacity. So instead of paying the QF zero in those years when the utility does not need capacity, what Duke does is it levels, which is a form of net present value analysis that will sort of average, as it were, the values in those years when the off-taking utility does need capacity, with the zeros that apply in the years that it doesn't. So it gives more weight with the net present value analysis to payments in the near term, but it presents a single figure that can be paid at the same value, either on a nominal levelized basis or a real levelized basis. It can be paid to the QF.
Okay, and a critical component of that is there has to be a projected capacity need based on in the term of the contract. So you're forecasting a future term of avoided cost, and so hypothetically, if similar to the initial rates offered at Cherokee, if it's a 5-year term, but the first year of need is in 2028, then there would be no capacity value needed that could be levelized. Is that accurate?
Where you can levelize zero and you get zero.
I was a history and poli-sci major, so that math is beyond me, but I think I will accept that subject to check.
Okay.
All right. So we talked about the fact that the Act 62 avoided cost proceeding was a heavily contested proceeding where the issue of first capacity need was a contested issue. And I think you said that that was the part of the order that you assessed or reviewed in developing your expert testimony. Is that correct?
Yes, I reviewed it.
Okay. All right. So just returning back to this order 881 again, which we spoke about, 881A, which is just the called the corrected version issued January 2nd of 2020. This is I'll submit that this is the section of the order that addresses the utility's capacity need. It would be helpful if I hit the share button. All right. Can you see the order that I have here again, Mr. Strunk? Is that visible to you?
Yes, it is.
Okay. All right. And let me read this language. And then before I get there, this is the explanation just below that where Duke is explaining the concept of levelization and generally explains it in a similar way to you did, so that it's to credit the QF for future avoided capacity so long as the utility has an avoidable capacity need within the avoided cost period. So seems to be good alignment there between your testimony and what Duke was trying to accomplish in the levelization of avoided cost rates provided to QFs. Is that fair?
Yeah, there's no dispute about that calculation.
Great. All right. But there is dispute about the timing of when that avoidable capacity need occurred between your proposal and the company's methodology for calculating their avoided costs that they use for Cherokee. Isn't that correct?
That is correct, yes.
Okay. And so this I will submit to you is the commission's order summarizing Duke's testimony. This is not the commission's finding conclusions, but it says Duke witness Snyder testified DEC's projection of its first avoidable capacity need occurs in 2026, while DEP's first avoidable capacity need occurs in 2020, consistent with the company's 2019 IRP update filings. So we spoke a moment ago about the November 30th, 2018 prior standard offer filing, where it was based on the 2018 IRP and reflected the avoided capacity that the companies had at that point in time, correct?
Yes, we did.
That was the prior exhibit we discussed. And so this now is 2 years down the road, let's say, and the companies have filed their 2019 IRP update filings. And there's been a shift in the year of need for DEC, not for DEP actually, remained 2020, but the company's methodology remained the same in terms of the approach they took to calculating the avoidable capacity need. Would you agree with that?
Yes.
Okay. And so this is the proposal, so to speak, that the commission is reviewing in this order in terms of assessing the methodology to calculate avoided capacity value. Do you agree with that?
Yes.
All right. So now I've moved down to the section that says commission determination. This is on page 89 of order 2019-881A. And this is the commission evaluating the testimony before it and establishing its conclusion regarding the methodology of how to appropriately calculate DEC's and DEP's avoided capacity for both standard offer QFs as well as for large QFs. And I'll just read the language here. The commission finds that DEC and DEP have appropriately identified their first avoidable capacity needs as presented in their 2019 IRP updates. ORS expert witness Ori testified the company's use of the recently filed 2019 IRPs was appropriate, reasonable, and transparent, and the commission finds merit in its testimony. So what does this commission determination mean to you in terms of the commission's assessment of the methodology that Duke was using to calculate avoided capacity costs at this point in time?
Right. So what this means to me is that, well after the Cherokee and Duke initial exchange, and well after Cherokee decided to put its capacity to DC, the commission resolved the uncertainty around what the appropriate avoidable capacity need is. However, as I explained in my rebuttal testimony, this was not the law of the land that was in play when in September and October of 2018. At that point, there had been a commission decision in North Carolina that had rejected Mr. Snyder's method, and the result of that NCUC proceeding had been used by the parties in South Carolina to set avoided capacity costs. So while this does resolve the issue, it wasn't, there was no way to know that this was how the commission was going to make its determination as of when DEC and Cherokee were looking at avoided costs in September and October of 2018. This is a number of years later, and there had been a decision that set the PP rate where the NCUC had taken a different view and had rejected Snyder's proposal. So that while it does resolve the issue going forward, it doesn't resolve the issue as of the time when Cherokee put its capacity and energy to DC.
A lot to unpack there, and a lot you addressed in your rebuttal testimony, but not in your direct testimony. So I'm sure we'll have an opportunity to do that. But you would agree with me, would you not, that this is the law of the land, I guess, as you said it, for any QF that was a standard offer 2 megawatt or less from November 30th of 2018 forward. That's what we established earlier based on the ordering paragraph of when these rates apply. Is that correct?
Yes, subject to check that seems to be the case. Yes.
Okay. And so Cherokee approached Duke in September of 2018, and Duke provided those avoided cost rates based on its methodology that it used to calculate avoided costs in October 30th, I think it was 31st actually of 2018. So 30 days before this standardized methodology applicable to standard offer QFs will become applicable on a going forward basis. Agree with that?
I agree with that. The order is several years later, but that was when it was filed. Yes.
Right. And so Duke had been taking steps to update its standard offer tariffs since November 30th of 2018, correct?
Yes.
Okay. But the issue is not about the standard offer tariff, because we've established that Cherokee is somewhere between 43 and 49 times bigger than will be eligible for Duke's standard offer tariff. It's a very large cogeneration facility that would in no conceivable way qualify for the standard offer, correct?
For the standard offer PP. That's right.
Right. And so it's your contention then that the appropriate methodology that the companies should apply would be dictated by the prior order that you referenced going back to your original testimony in order 2016-349. Is that correct?
That was the latest we had heard from the South Carolina Commission at the time that Cherokee put its energy and capacity to DC under purpose.
Okay, and just to pause here, Mr. DeGrandis, I neglected at the outset to provide to you all in email form the 2 cross exhibits that I was potentially going to use. So I just sent that to you and Mr. Pringle a few minutes ago, and I apologize for that. But I've been sharing them on the screen here, and it seems like we've been moving along fine. But if there's any issues there, please let the chairman or myself know.
Thank you, Mr. Pressburst. I would just ask Mr. Strunk that if any of these exhibits, if you need time to review them in order to answer council's questions, please so indicate. Thank you.
Very good. All right. So moving to the order that you referenced, and Mr. Chairman, I did list this as a potential cross exhibit. Well, we might as well do it as 2 pages. Mr. Chairman, I'd like to have this be Strunk cross exhibit, pre-marked as Strunk cross exhibit 1, be entered into the record as the next hearing exhibit, if I could, please.
All right, Strunk cross exhibit 1 will be entered into the record as hearing exhibit 11. And before you continue your cross examination, let's take a 15-minute break. We're in recess for 15 minutes. Good afternoon, ladies and gentlemen. Welcome back to the Public Service Commission of South Carolina. We're here in docket number 2020-263-E. Present in the hearing room, we have Commissioners Thomas, Powers, C. Williams, J. Williams, and Belzer. Joining us virtually, we have Commissioners Urban and Caston. Duke Council, please proceed.
Thank you, Mr. Chairman. Mr. Chairman, before I proceed, just a question on logistics for today's hearing. How late does the commission anticipate that we will go this evening?
So no later than 5 o'clock, and now's a good time to state that I have a medical procedure tomorrow, and my colleagues have informed me they would like for me to participate in this matter. Meaning we will be in recess until Thursday morning at 9 o'clock. And I'm sorry, give me a second. Yeah, so we'll start at 9 o'clock on Thursday. We have a transportation hearing that will probably take about an hour, which means we will recess at 10 and then come back at 11 and try to finish up on Thursday. And if we can't finish Thursday, we will go until Friday. But as for this evening, we will finish no later than 5 o'clock, and quite frankly, depending on what we have left with this witness, we may just end after this witness, just depending on what the time looks like. All right, does that answer your question, sir?
It does. Thank you, sir. We'll plan based on that. All right, Mr. Strunk, back to you, sir. And Mr. Chairman, just to confirm for the record, you have, I had asked that the Commission's order number 2016-349, which had been pre-marked as Trunk Cross Exhibit 1, that be entered in the record, and I believe it was as Hearing Exhibit 11. I just want to make sure I am starting at the right place.
Yes, sir, you are correct.
Very good. Thank you. All right, Mr. Strunk. So we were just, maybe to try to recap where we were, we had spent some time discussing the methodology that companies had used subsequent to November 30th of 2018 for all standard offer QFs and for large QFs, and walk through Order 2019-881A, in which the Commission approved that methodology as the appropriate implementation of PURPA for DEC and DEP in South Carolina. Is that correct?
Yep.
Okay. And just returning briefly to your testimony on page 10, the same question 14, you started with that Order 2019-881 and then referred back to an earlier Order 2016-349 as informing your assessment of the appropriate methodology for calculating avoided capacity value for Cherokee. Is that correct?
That's right.
All right. And so, and I think you alluded to this, so I'm going to try to move this along quickly, but you said this is a settlement, and I think on lines 19 through 20, you kind of allude to that by saying collaboration amongst stakeholders. The Commission approved the option B rates that had previously been accepted in North Carolina, at least in part, for variable 5-year and 10-year terms for QFs 2 megawatts and under. So only focus on the standard offer here. Is that correct?
That's right.
Okay. And you may recall, since you said you testified in the North Carolina avoided cost proceeding in 2017, but do you recall that the North Carolina avoided cost rates were actually, there was a 15-year term and they were applicable to QFs up to 5 megawatts at that point in time?
Yes, I recall the 5 megawatt threshold.
Okay, so the Commission at this point was approving a more narrowly focused option B tariff than what was allowed in North Carolina at the time. Accept that? We can strike that. You don't have a recollection of it. It's been a number of years. We can move on. All right.
Thank you.
Sure. So I want to focus on the manner in which the commission approved this standard offer tariff. In contrast to the 171-page order the commission issued in the subsequent Act 62 docket in Order 2019-881A, where they were statutorily required to review and approve the methodology. They didn't do that here, did they?
Right, they didn't have to. The parties came together and agreed on a tariff.
But if there would have been an increase in rates under South Carolina law, the commission would have had to notice the proceeding for hearing. But because the tariffs will not result in a rate increase, the commission was allowed to approve the settlement without further investigation, which is what this language says here. Is that your understanding of the commission's order?
Mr. Chairman, I would object to the extent he's asking Mr. Strunk for a legal opinion. Mr. Strunk has an understanding as an economist. That's one, he can answer the question, but to the extent he's asking for a legal opinion as far as the state statutory requirements for whether hearings are needed or not, I would object to that.
Understood. I'm asking Mr. Strunk, or I'm sorry, Mr. Chairman, I should let you speak first.
You have the opportunity to respond.
I'm asking Mr. Strunk in the manner that he referenced and cited to this order and referenced collaboration amongst the parties in his testimony.
Right. Could you say that one more time?
I'm asking Mr. Strunk to interpret the order as he referred to it in his testimony and was speaking about collaboration amongst the stakeholders and the commission's approval of the avoided cost standard offer tariffs. So I withdraw any request for him to interpret South Carolina law. I'm just asking him to read the limited words on the page that the commission used to approve this tariff at the time.
As he referenced in his testimony.
Yes, reconstituted. I have no problem with that question, Your Honor. So I would withdraw the objection as the question is reconstituted.
All right. Objection withdrawn. Please continue.
Thank you. All right. Continuing on, to be clear, this approval relates to the standard offer tariff for QFs 2 megawatts or less, correct?
Yes.
And the commission did not approve any methodology that the companies should use on a going forward basis for either standard offer QFs or large QFs. They simply approved the rates in the tariff at that point in time, correct?
Right, and those tariffs, those rates had been adjudicated before the North Carolina Utilities Commission, and they approved them as part of the settlement.
Right, and so specific to rates for QFs above 2 megawatts, the commission gave direction in that regard, didn't they? And
yeah, that's right. That's what it says at the bottom of the screen there.
Thank you. All rates for QFs above 2 megawatts or otherwise ineligible for the standard tariffs shall be negotiated under PURPA and FERC's implementing regulations. Did I read that correctly?
You did.
Okay, so the commission in 2016 directed the companies to develop avoided cost rates based on the methodology the companies believed to be appropriate and to negotiate with large QFs above 2 megawatts. Correct?
That's right.
Okay. All right. Just one thing related to this. In Mr. Hansen's examination earlier, I think this was when Ms. DeMarco was asking him some questions. He was discussing Mr. Keene's 2018 response, and he mentioned that and I think I got the quote right, but rates that DEC offered in October 2018 seemed inconsistent with the published large QF rates in effect at the time. Just to be clear, to your knowledge, there is no large QF tariff prior to Act 62, correct?
I'm not aware of one now.
Okay. And do you know whether DEC was utilizing the same methodology that it presented for standard offer QFs in its subsequent November 30th, 2018 application in developing negotiated rates for large QFs prior to November 2018?
I don't know what DEC did with other QFs, but we've seen through the discovery process in this docket what DEC had done with Cherokee.
Okay, so let me ask it this way. Through discovery in this case or otherwise, Cherokee has not discovered any instances where DEC offered more favorable capacity rates to other large QFs above 2 megawatts than were offered to Cherokee. Is that correct?
I don't believe I've seen any other offers from DEC or DP to large QFs. All I know is how they DEC calculated the avoided energy costs for Cherokee as of using its September 2018 modeling.
Okay, so you don't have any basis to dispute Duke Witness Snyder's testimony that the capacity value offered to Cherokee was consistent with the capacity value offered to all other large QFs in the, let's say, the period prior to the 2019 IRP update being filed, that was calculated in the same manner based on the same assumed 2028 first year capacity need. They followed the same methodology. They used the same inputs and assumptions for all large QFs. Do you agree with that?
I don't have any data to agree or disagree. As I said before, I haven't seen any other offers made to large QFs.
Okay, well, if you don't have any basis to dispute the testimony that suggests they treated all large QFs the same, do you?
I don't have a basis to dispute it, but I also don't have a basis to agree with it.
Okay, so do you have any basis to dispute that the methodology, assuming it to be the case that Duke's testimony is correct, that they used prior to November 30th, 2018, when they filed the updated standard offers, that methodology they used for large QFs, they essentially applied the same methodology to standard offer QFs at that point in time?
And so the methodology that they used, that they presented in response to discovery, that was, that methodology did not take into account the dispatchability of Cherokee. So it may be that they were looking at, let's say, a 5 megawatt solar facility, and that methodology, which was sort of assuming must take energy, would have been appropriate in the context of an offer to a large QF like that. But with respect to Cherokee, the methodology that was applied to develop the October 2018 offer did not take into account Cherokee's dispatchability and was based on an assumption that must take QF energy and didn't reflect the value of a dispatchable resource like Cherokee.
But Mr. Strunk, you would agree with me that that's a different issue than the issue of when the utility has their first year of capacity need. Isn't that correct? Assessing the dispatchability and the value of that in the rate design that you use to calculate avoided cost is a different issue than the issue of when the utility has its first year of capacity need and how they levelize those avoided capacity rates to fairly pay the QF, but also not have customers pay for capacity that the utility does not yet need. You agree with that?
I agree that there are two issues, but on the last question you asked me, you were asking about whether the methodology was applied to all large QFs, and I was just simply saying that it doesn't necessarily make sense to apply that across the board if the large QFs have different operational characteristics, like Cherokee, for example, has dispatchability as a valuable as part of its value proposition to Duke. But I agree that those are two separate issues, whether you levelize or whether you take into account dispatchability.
Right. And so in terms of the methodology, the peaker methodology the company used to quantify its avoided capacity and energy needs based on its first year capacity need in this IRP, you don't have any basis to determine that they didn't consistently apply that to all QFs, either prior to November 30th, 2018, large QFs, or subsequent to November 30th of 2018, all QFs, both standard offer and large QFs. Is that correct?
Mr. Chair, I just object to the extent there's like 3 things packed into there. Maybe council could just go over one by one so the record's clear when Mr. Strunk responds.
Mr. Strunk, did you understand the question?
Yeah, I thought we had been over at least the first part of it, but we can walk through it.
Sure. Same methodology applied to large QFs prior to November 30th of 2018 when the companies filed updated standard offer rates. That was applied and presented in the avoided cost application I showed you as Exhibit 10, I believe, earlier. That was using the IRP to determine the first year of avoidable capacity need. You would agree with me that you don't have any basis to suggest they weren't applying that same methodology to large QFs prior to November 30th of 2018.
I'm sure you've asked that question to me before, and I believe I answered. I have no basis to agree or to disagree because I haven't seen the offers it made to other large QFs.
Okay, fair enough. Well, I think Duke's witnesses can answer that. Could you turn to page 13, lines 6 and 7 of your testimony, please, sir?
Yes.
Okay. Can you read that for the commission, please?
I can. It says DEC's decision not to provide avoided capacity cost compensation to Cherokee was discriminatory.
Okay. And in my understanding of the word discriminatory, you're making a comparison where someone's getting advantaged and someone's getting disadvantaged. Is that fair? Someone's getting more favorable treatment and someone's getting a less favorable treatment, just at a very high level. Okay.
That's an okay characterization. Yes.
Okay. And so the premise of your testimony, if I understand it, as it relates to avoided capacity cost, is that you went back and looked at the standard offer rates that existed prior to November 30th of 2018 and recognized that there was capacity value there and said that capacity value should also be paid to Cherokee, which was a large QF. Is that correct?
That's right. So it didn't make sense for a new contract, whether it's with a small QF or a large QF, to have a different avoided capacity cost. If Duke either has an avoided capacity cost or it doesn't, and to give a rate to one QF with an avoided capacity compensation and not to another is discriminatory.
But you don't have any basis to make the assertion that Duke was treating large QFs above 2 megawatts that were not eligible for the standard offer any different than Cherokee, correct?
So again, there are 2 issues. There's the one issue as to whether the capacity cost was treated in the same way, and the other question is whether the dispatchability was accounted for. And as I've said many times so far this afternoon, I don't know what Duke was offering to the other QFs.
Okay, and focusing on the capacity value, is it a fair comparison to compare Cherokee to other large QFs where Duke is calculating avoided cost rates based on its most recent IRP, most recent assumptions at the point in time the request is made? Or do you compare them to a standard offer tariff that was approved 2.5 years ago and is fixed until it's updated?
Well, the answer to that question is in my testimony. I didn't think it was appropriate for Duke to prejudge. The IRP hadn't been approved by the commission, and as you know, these these avoided capacity need dates are very contentious. In other states, commissions have disagreed with the utility as to what the appropriate capacity need date is for a host utility and for application to avoided cost pricing for QFs. So given that it is highly contentious and that the issues were going to be before the commission, it's my opinion that it was unreasonable for Duke to prejudge the outcome of that hotly debated and heavily disputed topic. And particularly at the same time when it was applying a full capacity value to under a tariffed rate that had been authorized by the commission.
And Mr. Strunk, just to ensure we're clear that the commission, when they adjudicated this issue for the first time in at least a decade, found the methodology that DEC and DEP were applying was appropriate based on their IRPs, supported by the ORS as reasonable, appropriate, reasonable, and transparent in the Act 62 avoided cost proceeding, and that extended for standard offers back to November 30th of 2018, which was 30 days after the rates were provided to Cherokee. Is that correct?
Right, and this is a January 2nd, 2020 decision. As I said before, there was no way to know that was going to be the commission's determination as the parties were working to strike a deal in September and October of 2018. So we didn't know what the outcome was going to be. We didn't know the commission was going to make this finding. The North Carolina Commission had recently made a finding that was completely opposite to this finding. So yes, we know it now, but we didn't know it then.
And we'll come back to the North Carolina Commission because I think that's an issue in your rebuttal testimony. But to be clear, as it relates to large QFs, there was no approved methodology that Duke was required to follow coming out of that 2016 order. Is that correct?
There was no approved methodology, no. There are guidelines under FERC's implementing regulations, and I addressed those in my rebuttal.
Okay, and to be clear, the premise of your statement that Duke, the way that Duke calculated avoided capacity compensation for Cherokee being discriminatory was comparing it to the standard offer tariff that was approved in 2016 and that was effectively terminated November 30th of 2018, and comparing Cherokee, a 98 megawatt, very large QF, to small standard offer QF 2 megawatts or less. Is that the premise the commission would have to accept to agree with you that it was discriminatory?
That was a highly compound question, so if you could unpack it for me, I'd appreciate it. There were a number of elements to that.
Sure. What is the comparison you're making when you're saying that the compensation to Cherokee was discriminatory? What are the two things you're comparing?
And I've stated that. I've stated it in my testimony. I've stated it in response to your earlier questions. The comparison I'm making is to the what was available to the small QFs as compared to what DEC offered to Cherokee.
Right. Thank you. And so the commission would have to accept that that is a fair comparison versus to other large QFs to agree with your statement that the company's conduct was discriminatory. Isn't that correct?
Right.
Thank you. No further questions, Mr. Chairman.
Office of Regulatory Staff.
No questions for this witness. Thank you.
Commissioners, questions for this witness.
Chairman Webb.
Commissioner Caston.
Good afternoon, Strunk. Good to meet you virtually.
Likewise, Commissioner.
This was kind of touched on initially but I'll just kind of ask it just to clarify it in my mind. Are you an expert in evaluating avoided costs?
I've been retained by a number of utilities to analyze avoided costs, and it's something that that we do in the course of our consulting practice. Yes.
So yes, you are an expert in evaluating avoided costs.
Yes.
Thank you. Did Cherokee provide you any specific avoided cost needs from DEC?
No, Cherokee conveyed to me that they were interested in getting an avoided cost rate, and I analyzed what rates had been provided by DC to Cherokee based on the information that was available and the documents referred to in my direct testimony.
So Cherokee provided no specific follow-up avoided cost request from Duke companies or DEC. And did you have any specific avoided cost questions, information needs to Duke?
So the estimate of avoided costs as of October 2018 that I have used has two components. And one component is the avoided energy cost. The other component is the avoided capacity cost. On the avoided energy cost, I took DEC's energy offer as it was given to Cherokee. I didn't alter it, or I did see the backup that was provided by DEC as to how it was calculated, but I took that as given in determining a reasonable rate. And where I differed with DEC was on the capacity cost. And that's where I used the latest commission authorized avoided capacity cost.
And if I understood witness Nathan earlier, that a goodly portion of the delay, if I understood that correctly, was that DEC did not provide, I guess, requested avoided cost info. So I'm not sure if what was requested, but if they didn't provide what was adequate, how did you do an analysis to come up with that decision?
So my understanding of the factual circumstances and also of Mr. Hansen's testimony is that Cherokee asked for this data over the course of the negotiation process. Duke was not forthcoming in providing the data. However, as part of the discovery process in this docket, they did turn over the data, and the data that was missing, as Mr. Hansen explained, were the gas cost curves, all of the key inputs to DEC's production cost modeling, which is DEC uses the ProSim model, and that model depends on literally hundreds of inputs, if not thousands of inputs. And so to forecast the company's avoided energy costs. And inclusive in those inputs are gas cost forecasts, load forecasts, projected retirement dates for Duke's units, the projected dates at which contracts will roll off or come on. And so that the inputs to the ProSim modeling were provided by DEC as part of the discovery process here, but they had not been provided to Cherokee, as I understand it, at any time before then.
Do you know if Cherokee specifically requested that information anytime 3 years ago, 2 years ago?
Yes, my understanding of Mr. Hansen's testimony from this morning is that that they had asked Duke for the details behind the avoided cost forecasts, which include the gas curves, the other key assumptions.
So when you say details, Cherokee did ask for that specific information, not details, but specifically gas costs, load forecast, and the things you just mentioned. Cherokee specifically requested that information from Duke, and Duke did not provide it. Is that what I'm hearing?
Well, Mr. Hansen's really the witness to answer that question, but that's how I heard his testimony this morning.
Okay, that's not the way I heard it, but I could be wrong. As I understand it in your initial comments, that you work with utilities and developing PPAs and contracts and so forth. Is that correct?
That is correct, yes.
Is it reasonable for a utility to establish time frames for response from QF and contract negotiation?
Well, and for non-PERPA contracts, I think that would be reasonable. I don't think they can do it with respect to a PERPA contract because of this LEO, and particularly in the context of what we're seeing in this dispute. The parties were so far apart, right, that Cherokee believed that it should be entitled to a capacity payment and that it should keep its current tolling agreement. Yet DEC's position was that it was offering an energy-only must-take agreement. So in that context, it's unreasonable to expect that the parties would be able to bridge the gap from these two conceptually far apart and empirically far apart positions within a period as short as 60 days. And that's exactly why PERPA provides for the LEO and protects the QF if the utility is unreasonable in its negotiation tactics or delays or won't sign a contract. And so it's certainly not reasonable to have a 60-day exploding offer with a QF that has put its capacity to the off-taking utility. It may be reasonable for non-PERPA contracts, certainly not in these circumstances.
And then you're saying there should be no time frame in a PPA or any contract. It's just nebulous or open. I'm follow that. I'm sorry.
Yeah, and that's a reasonable concern that it would just be so open-ended, but it's not totally open-ended because once the parties do reach impasse, they can have their dispute settled by this commission, and so that's that's where we are. They tried to settle it through the mediation process. But it's certainly unreasonable from my perspective that given the course of dealing between Cherokee and Duke, where since 2001, the facility has been dispatchable, that Duke would want to turn that backwards and create this non-dispatchable must-take agreement. So start from that perspective. The initial offer that Duke put on the table was not a reasonable starting point. Disregard for a minute just the rate, but the form of contract was completely out of line with how the parties have been operating since 2001.
Well, if I recall, in some of the documents that we've seen today, I think from Duke, from the DEC, where it talked about capacity and I guess the intent or purpose there and other things. But I'm still struggling to understand that if 60 days isn't enough, maybe it's not enough, I don't know. But in the initial offer, within that 60-day time frame, or am I understanding you to say that that is not adequate time for Cherokee to determine whether that's a good offer or a bad offer? I mean, could they not have in that 60 days say we don't agree with it and send something back then? We do not agree, we need this information, whatever that is, specific. Did that occur?
So that would be a reasonable expectation of Cherokee, but my understanding of what happened was that Duke Energy Carolinas had provided a energy only priced, and as Mr. Hansen explained, it's the same deal team, it's the same individuals working on behalf of DEC and DEP. And what I understand is that the deal team directed Cherokee to start negotiating with DEP because DEP did have an immediate capacity need and therefore could pay a capacity payment. So I guess one explanation, and again, Mr. Hansen is better situated to speak to the factual circumstances, but one explanation for why Cherokee might not have gone back to DEC was that DEC directed Cherokee to start negotiating with DEP, and so it went down this different path based on the expectations that there would be a past payment in any offer that was forthcoming from DEP.
Well, I'm going on memory here, so that's an awful thing. But thinking about the documentation that we've seen today, I don't recall in that documentation, either from Duke or Cherokee, specifically where the question or concern relative to dispatchable and what's the other terminology?
Must take.
Must take. I don't recall any of that specific language being a stumbling block one way or the other. That said, we're kind of 3 years into this thing, and I'm still trying to understand why. And that you don't need to answer that question, because if you could wrap this up for us now, probably. Let me see. are you aware, and this may be similar to the question that Attorney Bright was asked, but I'm trying to understand this also. Are you aware of, or did you uncover any specific evidence that the Duke companies discriminated against Cherokee relative to their avoided costs, their PPA, their contract? Anything that you specifically are aware of that they treated Cherokee differently than any other equal to, larger than, smaller than QF?
Right. And I don't have the data to understand what offers they were making to other large QFs. I did highlight in my testimony the the difference between what was being offered to QFs under the Schedule PP and what was being offered to Cherokee. But as far as large QFs are concerned, I don't have the data to know one way or the other.
Well, I appreciate it. Thank you very much, Mr. Trump.
Thank you for your question, Commissioner.
Questions for this witness from commissioners? Sir, I have a couple of questions for you. Is it fair to say that the avoided cost today is less than the avoided cost when the LEO was made?
That is that is what we see in the evolution of Duke's offers. That the avoided energy cost has come down since Cherokee put its capacity to Duke in late 2018. So on the capacity side, we have seen an increase an acceleration of the capacity need date. So instead of 2028 being the purported need date, it's 2026 now. So lower energy avoided costs, slightly higher avoided capacity costs, but on net, I think the effect of the avoided energy costs going down is greater than the offsetting effect on avoided capacity.
Okay, thank you, sir. What impact would the avoided costs have on the ratepayer? Let's say that Duke agreed to the position that Cherokee has made in this case, that when the LEO was filed, if you will, or submitted, they put a stake in the ground. If the commission went with that position, what impact would the ratepayer see on their monthly bill?
So the recommended rate that I include in my direct testimony is a capacity rate of $110 per kilowatt year, based on Cherokee's operating cost and its heat rate. And given where gas costs have been in so far this year, we'd be looking at a total all-in cost of power from Cherokee under the rate I propose of about $47 per megawatt hour for both the energy and the capacity. And while you know, this is something that flows through, presumably flows through DEC's fuel and purchase power rider. And so, but the $47, given where the markets are, is quite a reasonable rate for energy and capacity. So I don't see it having a detrimental impact on customers, particularly since it's a relatively small portion of the Duke portfolio, but it would allow Duke to optimize the use of Cherokee's facility for the benefit of DEC's ratepayers.
Understood, but that rate is higher than what your calculation is higher than what was offered, though, right?
Well, yes, it's higher than what was offered. As Mr. Hansen explained, Duke seems to have disregarded the Leo date of late 2018. Its most recent offer was based on August 2020 gas curves and was made in February of 2021.
Understood, and the Leo date and the importance thereof has been made fairly clear regarding Cherokee's position. I'm really not interested in that. That point has been made, very well made, and I thank Cherokee for making that point. I'm just having more of a common sense conversation with you now about outcomes and results. So if I'm understanding you correctly, Cherokee's argument is that the Leo date is, I think you said September 2018, October 2018. That's when the stake should be put in the ground. However, Duke asserts, I guess it's an August 2020 date, something to that nature. Your rate is higher than Duke's, and the outcome of that would be the ratepayers would pay more for energy. Is that a fair line of reasoning or logic?
So ratepayers would pay more than if Duke and Cherokee were able to agree to a rate at Duke's proposed level. But my understanding is that Cherokee wouldn't take that rate. But if Cherokee were to take that rate, then yes, under the rate that I propose, it would be a higher cost to DEC's ratepayers than under the DEC proposal, which Cherokee has not. But at the end of the day, we don't know where Duke's actual costs are. This is the challenge of contracting for electric utilities. The avoided costs change all the time, and at any given point in time, a contract could be above or below. What's nice about the tolling agreement is that it's indexed to gas, so you're not going to get stuck in that situation where you've got this fixed must-take contract that is struck at too high a cost because relative to where gas prices eventually went. Let's say they go down, then if Cherokee and Duke had locked in that fixed price must-take contract, then if gas prices went down, the contract would look quite disadvantageous for Duke's ratepayers. But the way that the tolling agreement is structured, it's indexed to gas, and DEC can optimize the use based on how gas prices develop and how other fuel costs develop. But it's very hard to say, as we sit here today, what the ultimate effect will be on DEC's ratepayers. At any time an investment is made or a contract is struck, there's a possibility that when ratepayers see those costs, the market alternatives will be below or will be above whatever investment or contract was entered into by the utility. So it's a very difficult exercise that electric utilities face, and it's very common. They have to make decisions to invest in capacity, to contract with generators, and as they do that, those contracts could be in the money or out of the money. FERC has recognized that at the time of delivery, it could be well above or well below the price that was struck based on the LEO and a forecast avoided cost. So it goes both ways, and we don't know what the ultimate effect will be on ratepayers, just as we don't know what the ultimate effect of other utility contracting investment decisions will be.
Understood, sir. That's fair, but just to be clear, based on what your testimony is today and the position of Cherokee, Cherokee is asking the commission to use that 2018 avoided cost rate, which is higher than the 2020 rate. Is that correct?
It's my understanding that it's higher than the 2020 rate.
Which means that Cherokee is asking the commission to allow them to earn a higher rate, which will at some point, in some way or some manner, trickle down to the ratepayer, right?
So that's one way to think about it. I think the more the sort of PERP understanding is that Cherokee has a right to that rate, right? Because Cherokee put the capacity to Duke. So it doesn't matter whether or not the current forecast avoided cost is higher or lower. What matters is what it was at that time. So, yes, you could think about it as Cherokee's asking for a higher rate. You could also think about it as Cherokee's asking the commission to uphold its rights under PERPA. Duke has issued 4 offers that didn't fit with the structure of or the operational characteristics of this facility. So there's been a long negotiation process that didn't lead to a result that was acceptable to Cherokee, and Cherokee has come to the commission to ask the commission to uphold its rights under PERPA.
Yeah, I couldn't have stated it any better. I guess what's curious about all of this is that, well, let me just ask you, have you considered the other side of the issue, the average ratepayer that may be watching this matter? How would we, I don't know if you know this or not, but a lot of times in certain matters we have public hearings and we hear a lot from average ratepayers. And so I try to consider all the facts, consider the results on all the ratepayers, and there's quite a level of diversity amongst ratepayers. But how would you explain to the average ratepayer in the company's territory why the commission should approve a higher rate? I mean, is it as simple as PERPA says so? It's our right under PERPA, so that's what we're entitled to, and that's what we should get.
Right, and I think that's where I was bringing in the overall all-in cost of Cherokee, right? So at approximately $47 a megawatt hour, is that a reasonable rate? And if we look, for example, there are some documents on the state legislator website that describe Central Electric Cooperative and its agreement to buy power from Duke Energy Carolinas. And those documents show that the rate that Duke Energy Carolinas has charged to Central is about $60 a megawatt hour. And those costs are getting flowed through to ratepayers in South Carolina. So if you look at the overall total cost of procuring reliable capacity and gas indexed energy from Cherokee, it just doesn't look like a bad deal for ratepayers when we look at most benchmarks for generation, bulk power rate and generation cost.
Understood, sir. Thank you for your testimony. Those are all the questions I have. Are there any other questions? Vice Chair Belzer.
Thank you, Mr. Chairman. Good afternoon, Mr. Strunk.
Good afternoon.
I hope not to take too much of your time. In your appendix, where you kind of go through your rate calculation.
I'm going there right now. Thank you for your, okay.
You have an acronym VOM, and I haven't located where that is defined. Can you tell me what that is?
Yes, I apologize for not specifying that. That's variable O&M.
Okay.
So as the facility produces, in addition to the cost of fuel, there's some variable O&M costs, very small amount of cost, but it's compensated under the existing agreement.
Okay, and under the existing agreement, is Duke paying for a portion of the fuel used at the plant as well as variable O&M cost?
Yes, so Duke supplies the fuel under the current agreement, and so the cost of fuel is covered by Duke.
And under the under the proposal that Duke submitted to or responded to Cherokee with, would Duke continue to pay for a portion of the fuel or not? Or had they even reached that point yet?
So my understanding was that the intent of the first, I don't know if it was 3 or 4 offers from DEC and DEP, were putting the operational decisions in Cherokee's hands. However, as Duke's sort of position changed over time, and in the last February 2021, that was the first written offer with a dispatchable agreement. Under that arrangement, my understanding is Duke would pay for the gas and supply the gas. So it would be a continuation of the existing framework. But in the earlier offers, as I mentioned, it would have been on Cherokee's it would have been Cherokee's responsibility to procure the gas and to dispatch the facility.
And that last February 2021 offer you just referenced, that's when I think we're talking about DEC now, DEC. That was when they also made the 10-year term?
That's right. They extended it to 10 years. That's correct.
Okay. Now, when you talk about in your rate calculation of an all-in rate, does that include cost of fuel, or is that based on the February 21 continuation of the prior agreement or terms of the prior agreement, I reckon?
It's the all-in cost for DEC. So it would encompass the cost of fuel, and it would encompass the capacity payment that was, or sort of reservation payment that's made under the tolling agreement. So it's the total cost of power for DEC taken from this facility, including fuel.
Including fuel, but Duke is paying for the fuel cost.
Right, so, the $47 that I calculated was, reflects the fact that Duke would pay for the fuel costs and Duke would pay Cherokee a fee to be able to dispatch the plant at, at the facility's heat rate, which is capped under the contract, but the actual heat rate tends to be below the contractual heat rate cap. So it's the total cost. It's Duke paying for fuel and Duke paying Cherokee to be there, and to allow Duke the right to dispatch and get the power at basically the dispatch cost.
And that $110 per kilowatt year is your rate with Duke paying the fuel to operate the plant.
That's correct.
Okay.
So, so the cost of $110 per kilowatt year works out to about $21 per megawatt hour, assuming that Cherokee continues to operate at a 60% capacity factor. So if you spread that reservation charge or capacity payment over the projected output of the facility, it works out to be about $21 per megawatt hour, to which you add the fuel costs.
Okay. Now, in responding to a question from Commissioner Caston, I think you stated that DEC directed Cherokee to negotiate with DEP. Do you recall that?
Yes.
Did DEC, I'm using the word direct, as in we don't have a capacity need, go talk to DEP, or did DEC just say we don't have a capacity need until 2028 or 2026, whichever it was, but DEP has a capacity need in 2020, and then Cherokee elected to go file with DEP? Which is it?
Well, I'd prefer Mr. Hansen I wasn't involved in those conversations, so I think that question would be better directed when Mr. Hansen comes back to address
Okay.
rebuttal to.
Well, I'm just curious.
My understanding was that it was that DEC directed Cherokee, but Mr. Hansen was part of those conversations, and I was not, so he's better positioned.
I appreciate that. I just want to make sure I was understanding the term directed, but I appreciate your response there. Mr. Strong, thank you for answering my questions, and thank you for your testimony today. Mr. Chairman, that's all I have.
All right. Any more questions from commissioners?
Mr. Chairman?
Commissioner Irvin.
Thanks, sir. I'm wondering if in your negotiations, you included the Office of Regulatory Staff. Were they ever involved in negotiations?
So, again, it's Mr. Hansen who was involved in the negotiations. I was not involved in the negotiations.
I understand. So let me ask it this way. Are you aware that ORS is taking a position that there'd have to be a true up if we go back in time?
I understand that was testimony from ORS and subject to check. That sounds like what was proposed, but I'm not familiar with it in depth. But I also heard from Mr. Hansen that I think there would be there was some acknowledgement of a refund over some period when the rate reset.
Well, the Office of Regulatory Staff was very helpful to the commission recently in getting a major rate case resolved. And I'm just wondering, since we've got a day off tomorrow, would you be willing to recommend that attorneys for your client and for the company, and to perhaps touch base with ORS and see if they have a solution, because sounds like perhaps something could still be worked out given circumstances.
Yeah, to the extent that the parties can come together, that's always a better solution.
That's what we think, and so you've got no hearings tomorrow, and perhaps you can take advantage of that time to. I would encourage the parties to communicate with each other and see if you can't reach a middle ground, and include ORS, because they're going to be part of the equation. As the chairman indicated earlier, we want to make sure that ratepayers are fairly treated, and so perhaps that piece of the puzzle could be included in any negotiated settlement. Thank you, Mr. Chairman. No further questions.
Chairman Williams.
Commissioner Caston.
Sorry to apologize for bothering you again, Mr. Trump, but Commissioner Chairman Williams and Vice Chair Belcher, triggered some thoughts, and what I think I have heard from you and Mr. Nathan is that the commission is bound by PURPA. That almost sounds like we have to do this because the stake that's put in the ground established the ground rules. The avoided cost, the rate. Am I misunderstanding that?
My understanding, and I'm not a lawyer, but in terms of the implementation of PURPA is that at least that my understanding is that the parties have put it to the commission to determine, to confirm that Cherokee did indeed establish the LEO, and to confirm what a reasonable rate is at the time of the LEO. So the commission has discretion in setting a reasonable rate that's reflective of avoided costs at the time of the LEO. But PURPA does bind in locking in the LEO date for the QF.
Does PURPA not also state that the utility, in essence, is not required or should not pay more than their avoided cost of what they can do it for? Is that correct?
Right, but so that's the concept, but the concept can be implemented in one of two ways. You can do it at using a forecast avoided cost at the time of the LEO. And so PURPA assures that the avoided cost that's forecast at the time of the LEO is consistent with the utility's then forecast avoided costs. So, or at the QF's option, it could be an avoided cost rate based on avoided costs at the time of delivery. So there are two ways to think about avoided costs. You could think about them on a forecast basis as of the date of the LEO, or you can look at them at the time of delivery. And so the QF has the option. My understanding is that Cherokee elected to take the forecast avoided cost at the time.
Then if that's the case, if what I think I've understood Mr. Nathan say, then theoretically, at any point in the contract, the QF could set a stake in the ground because they think that they would have a better favorable rate for the QF, say it was 2017 instead of 2018 or 2015. I don't know what the numbers would be, but I'm saying the logic to that, right now I'm struggling with that logic because Chairman Williams is correct. And that, you know, as a commission, we weigh not only many factors, but many concerns and many constituents. The utility, interveners, the QF, the customers, consuming public. So I'm not sure how comfortable I feel that that stake in the ground is the absolute gospel, so to speak, that establishes a number.
Right. So it establishes a point in time at which the forecast is to be made, and the parties can dispute the number based on that point in time. But at least the FERC orders on this are pretty clear that this is designed to protect the QF from delay tactics by the utility or the utility refusing to execute a PPA in a timely fashion, so that the QF won't then be disadvantaged later in the process.
So is it possible, you're saying it's possible for the electric utility to use the delay tactics? Is it also possible for a QF to use delay tactics?
Well, if the QF were to use delay tactics, so if the negotiations between Cherokee and DEC were deemed to be delayed by Cherokee, there would still be the date at which Cherokee put its capacity to DEC. So I'm not sure how that would really change the appropriate avoided cost forecast data. The whole thing about PURPA, as Mr. Hansen explained, is that utilities were, before PURPA, really, in many cases, refusing to deal with independent power projects. And PURPA gave independent power a market. It gave developers of small power producing facilities and cogenerators a place to sell their output. And so the regulations are more designed to protect the QF, and they protect the utility really on the rate side by assuring whatever the date of the LEO is, that it's based on a forecast avoided costs. So there is protection both for the utility ratepayers and for the QF, but usually it's the utility that where these disputes arise, it's usually the QF views that the utility hasn't been reasonable in implementation, and that's what FERC was trying to head off when it came up with this LEO concept.
I understand, but if I understood what I read in the FERC and the PURPA regulation of what was shown on the screen earlier. Now, we didn't see the whole thing, and I don't recall the whole thing. But am I understanding you to say words in your mouth, but it almost seemed as though you were saying it's intended to prevent the utility from delaying things or stringing them out, but not the QF. In other words, the QF has more rights than the utility. Have I interpreted that correctly?
Right, and I cite the specific orders in which FERC has made that very clear in my direct testimony. There are orders where the FERC is very explicit that it is designed to protect QFs from utility delays. And I haven't seen any FERC orders that talk about the utility being protected by QF delays.
Repeat that last part. You haven't seen any orders that protect the utility from QF delays? Is that what you said, or did I misunderstand that?
Yes, that's what I said.
So am I to assume then that if that were to occur, that would be appropriate or okay?
Yeah, I don't think delays by either party are appropriate or okay. Just that there's a long history of utilities and QFs having disputes, and FERC's orders have been clear in their protection of QFs, but I wouldn't endorse delays by any QF.
Understand, and I appreciate that. I guess we're going on 3 years now, and as I look at the chronologies that have been shown, there seem to be some long gaps, long documentation gaps, long letter gaps, which I think should cause a little concern. Agree?
Right. So, yeah, certainly the documentation could have been more complete, if that's the question.
Yes, thank you very much. I know you've been there a long time, and you're probably ready to end this. So I'll ask no more questions. Thank you very much, Mr. Strong.
Thank you, Commissioner Caston.
Any more questions from the commissioners for this witness? Redirect.
Yes, Mr. Chairman. In recognition of the schedule and the shortness of life, I will be very brief. While we pull up a exhibit that Mr. Bryceworth used in cross-examining Mr. Strunk this afternoon, I would like to make a request, Mr. Chairman, before I forget it. Earlier, Mr. Chairman noted that with regard to Mr. Hansen, we counsel and Mr. Strunk would be able to talk with Mr. Hansen after his direct testimony and before his rebuttal. We would request that we have the same understanding with regard to Mr. Strunk, that we would be able to talk with him after today and before his rebuttal testimony is presented.
Yes, if we complete his direct today, the answer to your question is yes.
Okay. Thank you, Mr. Chairman. Okay. Mr. Strunk, do you remember this regulation that Mr. Bryceworth asked you about today?
Yes, I did.
304. Is this a regulation that you've reviewed in preparation of your testimony?
Yes, it is.
Okay. My question to you is, you focus on section B5, which we've highlighted for you. My question is, you've mentioned PURPA, you mentioned FERC requirements, et cetera, and Mr. Bryceworth, in response to several questions he had, you noted several times how a LEO's projected cost could be different than the avoided cost at the time of the power is delivered. My question to you is, to what extent, if any, is this portion, this regulation formed part of or overall your support for your conclusion and your statements today regarding how projected costs could differ from avoided cost at time of delivery?
Right. So this regulation specifically calls out that they may very well differ, and that there is not a violation of this if the forecast avoided costs do differ from the avoided cost at the time of delivery. It's well known that the avoided cost at the time of delivery could be higher or lower than the forecast avoided cost, and FERC has recognized that.
Thank you, Mr. Strunk. You also use the term in the money and out of the money. I'm not sure everyone understands your reference. Oh, could you say on that regulation, please?
Mr. Chairman.
Yeah, could we just put back here at screen?
Vice Chair Belzer.
Yeah,
May I ask counsel, I just would like for the regulation to be identified. I think you are in regulation 304, but all I heard was B5. Could you identify which regulation you're referring to?
Certainly, Commissioner. This is regulation, PURPA regulation 292.304, which is rates for purchases. Mr. Briceward had several questions for Mr. Strunk this afternoon. I am focusing on subpart B, which is relationship to avoided cost, and specifically B5, which is the highlighted section, but it's all under the 292.304 rates for purchases.
Thank you very much.
Very well. And please ask for any clarifications as we go along. I just have a few more questions. Mr. Strunk, you were using the term in the money, out of the money. Could you kind of describe what you meant in the context of this regulation that we're looking at so that everybody's clear what you meant by that term?
Sure. If there's a forecast made of avoided costs, for example, when Duke presented its offer in late 2018 to Cherokee, it had an assumed peak hour energy avoided cost of $40.71 per megawatt hour. And so if Cherokee had taken those offers and subsequently the peak avoided energy cost had gone up, let's say, to $45 a megawatt hour, that would mean that the contract rate was below the then sort of avoided cost at the time of delivery. And so that would be a contract that looks to be in the money relative to avoided costs at the time of delivery because the contract rate is below the avoided cost. If, on the other hand, avoided costs at the time of delivery were to evolve so that the avoided cost at the time of delivery was below the contract rate, in this case, the rate was $40.71 for peak energy. If that avoided cost during peaks dropped, let's say, to $35 per megawatt hour, then the contract would be out of the money relative to the avoided costs at the time of delivery because the contract price would be above the then prevailing avoided costs.
Thank you, Mr. Strunk. Mr. Briceward also asked you questions about whether you were expecting Cherokee to be treated, I think the words were more favorably than other large QFs or even cogenerators. Do you recall those questions?
Yes, I do recall those questions.
At different points, you've mentioned dispatchability. While you're not arguing that someone should be treated more favorably, but to what extent can the State Commission take into account different attributes of a facility with regard to dispatchability or other factors?
So the FERC implementing regulations are quite clear on that. When the regulations that guide negotiations with large QFs are explicit in referring to dispatchability as one of the key attributes that should be accounted for by off-taking utilities and QFs as they negotiate PPAs for the sale of capacity and energy from QFs, from large QFs.
I'd like to scroll down, if you could, Mr. Waldman, down to section E2, and I just wanted to see if this is the section you were just referring to, Mr. Strunk, where it says, following factors shall, to the extent practical, will be taken into account in determining rates for purchases from a QF. Is this this is 292.304 subpart E2. We're still in the same regulation, 304, but this is subpart E2. Is this what you're referring to as far as PERPA regulations describing what other factors you could take into account determining a QF supported cost rate?
Yes, it is. So it's that point A there under 2, which says the ability of the electric utility to dispatch the qualifying facility. And that is actually one of the likely to be one of the differences between Cherokee and some other large QFs that may be selling intermittent power that can't be dispatched. And in that regard, this regulation indicates that that the dispatchability should be taken into account. So wouldn't surprise me for Duke to have a different analytical technique for Cherokee than it does for other large QFs that are non-dispatchable.
In other words, compared to renewable facilities that are completely intermittent, is that what you're referring to?
Yes, that's correct.
Okay. Thank you, Mr. Strunk. One last question. Mr. Bryceworth was asking you about to what extent you were relying on Schedule PP or other standard offers that Cherokee was not eligible for. So my question to you is, to what extent were you relying on data cost associated with avoided cost rates with respect to those standard offers? To what extent were you relying on them in coming up with your avoided cost recommendation here? And why or why not would that be appropriate in using avoided cost info from those standard offers and relying on them in some way here?
Right. So I did rely on Schedule PP, and the reason I did was because, as I explained in the cross-examination by Duke, the determination of an avoided capacity need and the methodology for determining avoided capacity costs is highly contentious. And the latest we had heard from this commission was the approval of the rates in Schedule PP. And that was the data that was available at the time. Duke made its offer to Cherokee in October 2018. So that's why I relied upon it. It was the latest capacity, avoided capacity cost data that had been approved by the commission.
Thank you, Mr. Strunk. Mr. Chairman, it's 5:01 p.m. I have no further questions, no further redirect.
You made sure to use up all that time.
No.
Ladies and gentlemen, we are going to be in recess until 9 a.m. on Thursday. Are there any questions before we recess for today?
Yes, Mr. Chairman, this is Jenny Pittman for ORS. I have a brief motion.
Yes.
Due to the scheduling change, I would like to move to excuse Dawn Hipp and have her testimony entered into the record via verification. She is unavailable all day Thursday and is not available Friday morning. I have notified opposing counsel, though they were probably preoccupied with the hearing and might not have checked their email, but I did let them know about an hour ago that I intended to do this.
Okay.
Mr. Chairman,
Yes.
it's Jack Pringle for Cherokee. I'm a little distressed that Ms. Pittman referred to Cherokee as opposing counsel, but I'll let that go for purposes of the motion. I understand the ORS's concern, and if there's, if she can't be, if Ms. Hipp can't be here, then I think we will end up acceding to the request, although we certainly did have, some cross-examination that we were going to do. But I think in the context of these circumstances, I don't know that we're in a strong position to oppose it, although we undoubtedly will reserve the right to, when we brief or use proposed orders, to make arguments about it. I also would probably, and this I'm sort of thinking on the fly, as to to the extent that Cherokee has a response to Miss, never mind. I'll leave it at that.
Attorney Pittman, is Ms. Hipp available Friday afternoon?
Yes, she is available Friday afternoon.
Okay. Attorney Pringle, you seem very concerned that Ms. Hipp would not be available to testify, and that you wouldn't get the opportunity to cross-examine her. And the commission's scheduling is not an excuse to interfere with the party's due process rights. So, if Ms. Hipp is available on Friday afternoon, I'm fine having her testify at that time.
I don't think I'm that concerned, Mr. Chairman.
Mr. Chairman, Frank Ellerby for the DEC and DEP. I haven't had a chance to consult with other lawyers or my client, but appreciate Ms. Pittman giving us a heads up. We do have questions also from Ms. Hipp, and we think ORS has an important role in the case. So if it could be, we'd be fine with us to get her when she's available on Friday. And so we would appreciate if we could handle it that way.
Understood. All right, Ms. Pittman, if you would make Ms. Hipp available Friday afternoon. I don't know if that's a hard after 12 o'clock, but we can talk about it more on Thursday.
Mr. Chairman, we could do that. Is there a set time I can let Ms. Hipp know to be available?
On Friday afternoon? Probably won't know that until the end of the day on Thursday.
Okay, that's fine. I understand. Thank you.
All right. Is there anything else?
Nothing further from ORS.
Sorry, Mr. Chairman, one question. Could you go over the schedule for Thursday again, if you don't mind?
We will reconvene at 9 a.m. We will go until 10 a.m. and then we will reconvene at 11 a.m.
Mr. Chair, one clarification. Am I excused from my direct testimony and only until I'm called on rebuttal, or?
Yes, sir, you are.
Okay, thank you, Mr. Chair.
All right, and just to give a stopping point for Thursday, my hope is that we can complete this with the exception of Ms. Hipp's testimony on Thursday, and we will go no later than 6 p.m. All right, any other questions? All right, we're in recess until 9 a.m. Thursday.
Thank you, Mr. Chairman.